consideration is Bill 25-5, the Uniform Commercial Code Amendment Act of 2023. Bill 25-5 was introduced on January 3rd, 2023 by Chairman Mendelson at the request of the Uniform Law Commission. The stated purpose of the bill is to make a number of amendments to the district's codification of the Uniform Commercial Code. Namely, the amendments add a new Article 12 named Controllable Electronic Records, which provides rules for transactions involving digital assets, including cryptocurrency, non-fungible tokens, and electronic promises to pay. The Uniform Commercial Code is a set of rules that facilitates commerce through the United States. It's been adopted in nearly identical form by every U.S. jurisdiction to ensure that the laws governing the transactions is substantially the same no matter wherever you are in the country. The UCC is updated periodically to keep pace with legal and technical developments. The amendments proposed in Bill 25-5 will ensure that the UCC continues to facilitate commercial activity by taking new and emerging technologies into account. Next, we will be hearing from public and government witnesses on Bill 25-456, the Tenant and Rowhouse Short-Term Rental Clarification Amendment Act of 2023. I introduced this measure on July 13th, 2023, and it was referred to the Committee on Public Works and Operations with comments from the Committee of the Whole. The stated purpose of Bill 25-456 is to amend the Short-Term Rental Regulation Act of 2018, which began to be implemented and enforced by the Department of Consumer and Regulatory Affairs in early 2022. The functions of short-term rental enforcement now fall under the Department of Licensing and Consumer Protection. The bill would make the operation of a property under the short-term rental law available to two classes of district residents that are currently excluded: rental tenants and owners of a two-unit property in certain zoning districts. Bill 25-456 permits a tenant to operate a short-term rental so long as they obtain written permission from their landlord and provide sufficient proof of residency. Prior to the implementation of the district's short-term rental law, tenants were not precluded from operating a short-term rental in their residence, which some residents used as an additional source of income. Further, Bill 25-456 clarifies Section 102 of the Short-Term Rental Regulation Act of 2018 to rectify an interpretation of the law that has caused owners of largely identical properties to be treated differently. A row house with a basement ground level apartment is a very common housing type in the district and exists in many different zoning districts. However, if such a property is in a residential zone, it's classified as a one-unit property with an accessory dwelling unit, the basement apartment. If it's in a residential flat zone, it's considered a two-unit property, meaning the basement unit would not be eligible for a short-term rental lease license under the current interpretation of the law. This would mean, to use a specific example, the owner of a property on the north side of Webster Street Northwest, the dividing line between an R3 and an RF zone, would be permitted to list a basement apartment as a short-term rental, whereas the owner of a nearly identical property on the south side of the street would not. Finally, we will consider Bill 25-151, the Open Movie Captioning Requirement Act of 2023. The stated purpose of Bill 25-151 is to require at movie theaters with more than one screen that at least 12% of each movie's weekly showings be screened with open captions. Further, the bill requires that at least half of these required open caption screenings be scheduled during peak movie attendance hours. A violation of these requirements is classified as an unlawful discriminatory practice pursuant to the District of Columbia's Human Rights Act of 1977. Bill 25-151 would also require a movie theater to advertise the date and time of showings with open captions. I look forward to hearing from our public and government witnesses today on each of these measures. All right. Do we have any council members who've joined the Zoom? Okay. We will acknowledge them for opening remarks when they arrive. I would like to provide some logistical announcements for today's hearing. We did have some technical difficulties earlier, which is why we started a little late. We believe those are resolved and that everyone should be able to fully participate in the hearing through the Zoom. It is being live streamed at briannecanado.com/live. In order to ensure we hear from all members of the public, I ask that all witnesses stick to their allotted time. Witnesses testifying on behalf of an organization will have 5 minutes to provide oral testimony, and all other witnesses will have 3 minutes. I'd like to provide some reminders about the Zoom platform and the committee's protocols for the witnesses participating today. All witnesses participating in this webinar are currently listed as attendees in Zoom, which means your microphones are muted and your cameras are off. But it's when it's your turn to join a panel for testimony, I will call your name and a member of my staff will invite you to be promoted to the panel. You'll need to accept that invite, and then you'll have the opportunity to turn on your video and unmute yourself when it's your turn to testify. There will be a frame that includes a clock keeping your time. When your time is up, I kindly ask that you conclude your remarks so that we can ensure everyone has had a chance to be heard. For any technical difficulties, you can send a message to Ariel Ardura or David Meny, who are both logged into the Zoom, and they will follow up with you. We're providing cart captioning services for this hearing. If you'd like to enable or disable captions, you can do so in the settings on the bottom bar of the Zoom window. ASL interpreter services are also provided. To view the interpreter, you can select the interpretation menu at the bottom of the bar to activate the ASL channel. Additionally, if you're having trouble gaining access to the Zoom, please reach out by emailing publicworks@dccouncil.gov and we'll try to resolve your issue. I understand some witnesses are having difficulties with the link, which we will work to resolve. Okay. Now we will turn to our first measure on today's agenda, Bill 25-5, the Uniform Commercial Code Amendment Act of 2023. We're going to have both of our panelists up at once, so I will now call James McKay, Chair of the DC Uniform Law Commission, and Juliet Morello, Public Witness. Before you provide your testimony, Mr. McKay, I'm going to administer the oath to you as one of our government witnesses. If you could raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Great. Thank you. And then Professor Morello, if you'd like to share your screen for your presentation, you should be able to do so now and begin your testimony.
Oh, okay. Thank you. All right. Can everybody see that?
Yes, we can see it. Thank you.
Okay, terrific. So I'm Juliet Morello, and I serve as a commissioner from Pennsylvania in the National Conference of Commissioners on Uniform State Laws, also known as the Uniform Law Commission. I was the vice chair of the drafting committee for the 2022 amendments to the Uniform Commercial Code, which drafted the act that you are considering today. And I appreciate the opportunity to appear before you today to testify in support of Bill 25-5, the Uniform Commercial Code Amendment Act of 2023. The Uniform Commercial Code governs transactions that you all are involved in every single day. What I'm going to talk about is the crown jewel of this set of amendments, which is Article 12 of the UCC, which provides a framework for transactions in certain types of digital assets. We call them controllable electronic records under the Uniform Commercial Code amendments. My PowerPoint has a lot of detail, so I'm going to hit the slides that actually are most important here. We revised the Uniform Commercial Code at this point because there were a lot of people transacting in commerce, transacting in digital assets and commerce. And when I say digital assets, I mean, among other things, cryptocurrencies, which individuals and companies are transacting in all the time without a framework that is consistent throughout the United States to determine who has property rights in what. So the Uniform Law Commission drafted a new UCC article, Article 12, which defines a new asset category called controllable electronic records. The two most important innovations in this article are that it provides a framework for what we call control, which is basically the digital equivalent of possession of an asset. That is really important in commercial law because when one has a tangible asset, there are certain rights that go along with possession. We did not have a similar framework for intangible assets, which are very important in commerce these days. So Article 12 provides for control of these assets, basically a framework that is equivalent to possession. It also provides rules that allow good faith purchasers to take these assets free of competing property claims. Control, as I said before, is basically digital possession. I mean, it's sort of the same as I am sitting in a chair right now and I can exclude you from that chair, or I can get up from the chair and allow you to sit in it. Well, control provides the same, control gives the same framework for intangible assets, right? If I have control of an asset, I can invite you to enjoy its benefits, or I can exclude you from those benefits. And I also, if I have control, importantly, I have the exclusive power to transfer the controllable electronic record. Take-free rules are extremely important. So let me give you an example involving money. If I hand you cash to pay for goods or services, you don't have to do a search of the public records to see if anybody else has an interest in that cash. That makes commerce operate. Right now, under the Uniform Commercial Code, if somebody gives me a controllable electronic record, cryptocurrency, I would actually have to check the public records to make sure if somebody else has an interest in it. So under Article 12, we have rules that make these controllable electronic records what we call negotiable. What I just described with respect to cash tells us that cash is negotiable. If somebody takes a controllable electronic record in good faith for value and without notice of property claims to it, that person takes free of competing property claims. The take-free rules apply only to the record itself, not to any property rights evidenced by the controllable electronic records. You probably have read a lot about non-fungible tokens. The law is really still unclear as to what that token really represents. So the Uniform Commercial Code recognizes that the underlying state property law is still unclear and does not grant any particular tethering rights in those tokens. The Uniform Commercial Code amendments also provide choice of law rules, which are very important. As you heard earlier, the Uniform Commercial Code is meant to be uniform in every United States jurisdiction. That is very important because right now states have gone out and they have tried to enact their own cryptocurrency laws, making life very difficult for judges, particularly bankruptcy court judges, who need to figure out people's rights in these assets. I think Mr. McKay is going to describe to you the waterfall, or part of the waterfall of choice of law that is provided in the UCC that actually makes the District of Columbia the default jurisdiction, but I will defer to Mr. McKay on that. The code amendments also provide amendments to other articles, particularly Article 9, which governs transactions in which somebody gives personal property as collateral for a loan. The Article 9 amendments incorporate the Article 12 innovations regarding control of a controllable electronic record. The Uniform Commercial Code amendments also address the issue of electronic money. Right now, under the unamended UCC, money is a medium of exchange adopted by a government. A few years ago, El Salvador adopted Bitcoin as money, and that sort of threw the Uniform Commercial Code, or wreaked havoc on the Uniform Commercial Code, I should say. because there was a possibility that Bitcoin could be considered money everywhere. So the Uniform Commercial Code provides that if a jurisdiction adopts an already existing cryptocurrency as money, that is not money, and that is important for UCC purposes. Right now, the amendments have been adopted in 11 jurisdictions and have been introduced in 17. I am happy to take any questions that you have for me on these amendments.
Thank you very much for your testimony and presentation. We'll hear from Mr. McKay, and then we'll turn to questions for both of you. Thank you.
Thank you. Good morning, Chairperson Joe and members of the committee. I am James McKay, Chair of the DC Uniform Law Commission. I appreciate the opportunity to appear before you today in support of Bill 25.5, the Uniform Commercial Code Amendment Act. As Professor was also Commissioner Jello said, the UCC has been enacted in every jurisdiction of the United States in essentially the same form, and is a backbone of commerce in the country. Because of the unique challenges, legal challenges posed by transactions involving digital assets, the National Conference of Commissioners on Uniform State Laws, which is sometimes called the Uniform Law Commission or NCUSL, undertook an extensive analysis of the law with the participation of hundreds of stakeholders. And the amendments to the UCC are the result of this process. It was completed last year, and it addresses commercial transactions involving digital assets based on emergency technologies, Bitcoins, non-fungible tokens, electronic promises to pay, or the prime examples. And the new Article 12, which Professor Jello mentioned, is entitled Controllable Electronic Records. And the word controllable is used because controlling an intangible electronic record is the equivalent of possessing a tangible asset. The amendments are needed to ensure that these assets are negotiable and permit the creation of security interest in them, so they may be used for collateral for loans. To ensure that the UCC remains relevant, controllable electronic records are defined to include not only digital assets using today's distributed ledger technology or blockchain technology, but also any assets that may be function similarly using future technologies. The bill also includes amendments to other articles of the UCC, Article 3, negotiable instrument, Article 4, bank deposits and collections, Article 9, secured transactions. Pardon me. Amendments to Article 3 and 4 keep the law current with federal regulations allowing the deposit of checks by sending a photograph to the bank. Amendments to Article 9 accommodate the use of controllable electronic records as collateral for loans and other obligations. And many other provisions throughout the UCC are amended to allow for electronic documents and signatures. The prompt enactment of these amendments by the council is especially important because the district plays a critical national role as a default governing law jurisdiction or choice of law jurisdiction for all commercial transactions in the country subject to the UCC, for which no state's law is specified by the parties to govern. In addition, the bill includes a few important technical amendments to Article 9 of the UCC completed by NCUSL in 2018, which clarify that governance interest in partnerships may not be used as collateral for a secured transaction without the consent of the other partners or co-owners. Therefore, I urge the committee to report favorably on Bill 20-5 of the UCC Amendment Act of 2023, and I would be happy to answer any questions.
Thank you very much for your testimony. Okay, so I think all of these can be for either of you. Can you explain why these amendments were necessary at this time, given that this is still developing technology? Between the time the amendments were drafted and now, there was a major crash in the NFT market. after hype died down. So do you see that market as transforming in ways that would impact the UCC?
Well, I'll let Professor Jello mention just generally, people have billions and billions of dollars of assets in Bitcoins. And if they sell them, they'll hit with a big capital gains tax. So they try to use them as collateral for loans, to borrow against them. And they really can't do that safely under the existing structure. And so, I mean, Bitcoins are here to stay, it seems, and non-fungible tokens are too. And electronic promises to pay seem to be the way of the future. And even though there might be fluctuations in the market, I think it's really important that there be a solid, reliable, predictable legal framework. But I'll let Commissioner Morello elaborate.
Sure. So thank you, Mr. McKay. So first of all, I'd like to say NFTs are kind of a sideshow here. This really is not about non-fungible tokens because, as I said before, I mean, really, the token legally under property law doesn't give anybody anything. That's kind of why the market crashed. People figured that out. But let's talk about the controllable electronic records, because I know there is a concern. People say, well, wait a second, you know, there are all these crypto bankruptcies and why are you doing this now? So when the UCC was amended in the late 90s, which were major amendments to Article 9 of the UCC, we were in a world of electronic transactions. People were concerned about how to make sure electronic contracts were enforceable and usable. In the intervening 25 years, electronic assets have emerged. And as Commissioner McKay said, you know, they are here to stay. People are transacting in Bitcoin, in other digital currency, I shouldn't say digital currencies, cryptocurrencies, and also he mentioned electronic promises to pay. I mean, those will become popular in commerce. So why do this now? Well, in the past 5 or so years, states have wanted to get out and be the crypto-friendly state, and that was led by Wyoming. And when states enacted their own laws governing these kinds of assets, they either on purpose or inadvertently amended the Uniform Commercial Code. That made actually choice of law questions really, really difficult because a Bitcoin might be considered one kind of asset in Delaware, but another kind of asset in Wyoming. And if somebody filed for bankruptcy with these assets in their estates, there would be very costly litigation to figure out what law applied. So the Uniform Law Commission and the American Law Institute, which is the other sponsoring body of the Uniform Commercial Code, decided that it was important to provide uniform rules that would apply across the country to facilitate transactions that are already happening. And that's an important thing to remember about the UCC. It is not a regulatory statute. It is a facilitative statute. And these transactions are happening. And this act is necessary to avoid really costly litigation about these assets.
Thank you very much. What's the process like for deciding upon amendments?
Pardon me, I'm sorry.
Sure. What's the process like for deciding upon amendments?
For deciding the Uniform Law Commission?
Correct. And who participates in that process?
Well, it's, every stakeholder who's interested has a right to participate, come to the meetings. I think Professor Morello, who went through the entire process over about 3 or 4 years, would be better to explain exactly what happened and what the process looked like.
Sure. So in general, the way the Uniform Law Commission decides to take on a project is it gets proposals from various entities that are then considered by the Uniform Law Commission's Scope Committee, which determines whether an act is is a good fit for a uniform law. Now, the Uniform Commercial Code has been the most successful product of the Uniform Law Commission. So, we know that the UCC is appropriate for uniformity because we want to make sure that people who are transacting in goods in the District of Columbia have the same governing law regarding those transactions as someone in Pennsylvania, because people sell goods between Pennsylvania and the District of Columbia. So in this case, the proposal came from the Permanent Editorial Board of the Uniform Commercial Code, which is a standing body that keeps an eye on developments that are governed by the UCC. And this body determines, gosh, does the UCC really work with this kind of development, or should there one day be amendments? So the Permanent Editorial Board is who proposed these amendments. But then what happens is it goes through this process where the scope committee determines, oh yeah, this is a good subject for uniform law that is enactable and is relevant right now. It goes to the executive committee of the Uniform Law Commission, which then decides whether or not to go forward with a project. A project always starts with a study committee. And so for a year, the committee, which was made up of commissioners who were appointed by their states, and then another group of people that were appointed by the Uniform Law Commission, by the American Law Institute, which is an elected body of lawyers. The group studied developments in commercial law over the past 25 years to determine what should be the subject of a uniform law. Now, as Commissioner McKay said, these are open processes. And so stakeholders are invited to come to these meetings. So who are stakeholders in this case? Representatives of banks, representatives of consumer groups, people in the crypto industry, anybody with an interest in these kinds of transactions. So the study committee worked for a year, proposed that we go forward with these amendments, and then there is a 2-year drafting process. Now, this actually happened all during the pandemic when we weren't having in-person meetings. So we had a good number of Zoom meetings in which hundreds of stakeholders participated. So it wasn't just 18 people deciding what should be the law. It was people who work in these businesses, people who are affected by these businesses, all of whom have full participating powers in the committee process. I mean, they can't vote on the final product, and they don't have floor privileges at the Uniform Law Commission annual meeting, but they are full participants. So that's basically how the process works. But if you have further questions about the process, we're happy to answer.
Thank you very much. Appreciate that explanation. There have been a number of problems with blockchain-based technologies used in exploitative ways, including a significant amount of scams. Would these amendments address those issues?
I'm going to defer to Professor Jello for that.
Sure. So, there are lots of, that question raises lots of issues, and it's a great question. So some of those issues really can only be addressed by, regulatory changes, and, usually in the hands of the Securities and Exchange Commission. What these amendments will do, though, is make it clearer who has property rights in these assets. So, right now, if somebody wants to give cryptocurrency as collateral for a loan, sometimes that person finds that he's actually sold his cryptocurrency, right? And, if the crypto exchange files for bankruptcy, there's nothing for this person, okay? So what these amendments do is really provide a framework to make somebody's property rights in these assets clearer, right? So it's sort of like if you were to give a mortgage on your house and there was no legal framework for giving a mortgage on your house and you find that your house disappears, and I know unfortunately in some communities that does happen, it's sort of the same thing, right? I mean, we have a clear law of mortgage financing, and there's still scams in mortgage financing, but there's generally a clear property law. This kind of does the same.
Okay, that makes sense. Thank you for that. Is there any concern that including cryptocurrencies in the UCC is enabling some of that unsavory behavior?
I don't think so, but again, Professor Morello probably has something to add to that.
Yeah, thanks. So one thing that I think I didn't make clear enough in my testimony, although I think Commissioner McKay did mention it, is so, if you were to read these amendments, and they're hundreds of pages, so I don't expect many of you will not see the word cryptocurrency anywhere in them. Why? Yeah, we know we're writing amendments that affect transactions in cryptocurrencies, but our intention was to write a technology neutral statute that would apply to not only digital assets that exist now and are used in financial transactions, but digital assets that may emerge in the future. And so, we recognize that intangible property is not going away. The legal framework has always been a little bit confusing because 25 years ago, the only intangible asset that anybody thought about was intellectual property, and Bitcoin are not intellectual property. So, if it will make it easier to scam people, I don't think so, because again, what the Uniform Commercial Code does is that it provides a framework for transactions to make sure that contracts are enforceable, property rights are appropriately transferred, and preventing bad guys is really the province of regulation, and in this case, mostly the SEC.
Makes sense. Thank you. I know that in some states, there's been concern about these amendments enabling the federal government to issue digital currencies. For the record, can you explain more about those concerns and the response to them?
Again, I think it's basically misunderstanding of what the law does on the part of a few people in talk shows who wanted to make a big thing about nothing. We've actually responded to that very thoroughly in I think one of these papers that I submitted, but I will make sure it's in the record. But I would like Professor Morello to go into more detail.
Sure, happy to. And, I think what Commissioner McKay said that's most important is it is the result of a misunderstanding. So, there's probably nowhere where people are more aware of the difference between federal law and powers given to the states than you folks in DC, right? And so a state cannot issue a central bank digital currency. And the Uniform Commercial Code is state law. So again, I mean, it's facilitating transactions and various types of assets, but in no way, I mean, first of all, one of the accusations, and Commissioner McKay mentioned talk shows and things like that, one of the accusations leveled against the Uniform Law Commission was that we were working with the Biden administration to make sure that the United States could issue a CBDC. One thing that is very important to remember about the Uniform Law Commission is that we're about federalism, right? We are about giving states, and in your case, the District of Columbia, certain powers because you don't want the feds to, or we don't want the feds to exercise those powers, right? So commercial law is the province of state law, and it's important that it be uniform. So yeah, I mean, the biggest response to that is something that Commissioner McKay said. It's a misunderstanding. State law can't do this. The Uniform Law Commission was not working with the president to pave the way for a CBDC.
Thank you very much for that. As we move to mark up this legislation, which is the term we use when we advance it, it would be good to have on record why is it important to make as few changes as possible to the amendments.
Certainly, we'll follow up with a memo to that effect.
Thank you. What would you say to a constituent in the district who's concerned that this is a non-elected body setting policy instead of council?
Well, each state legislature decides whether to enact it, whether it's the interest of its state. And all the states and territories of the United States have decided independently that Uniform Commercial Code was important, and that it be uniform was important so that commerce between the states throughout the country can flourish and litigation can be reduced. So it's been one of the most important state laws for over 50 years.
Thank you. Finally, this one's a little bit tangential, but since we have some experts here, I thought I'd ask, as we're working through the tax revision commission process in the District of Columbia, do you have any advice on how we should be treating some of these electronic records and cryptocurrencies for tax purposes?
Well, that's a very interesting question, and I think that we do allow payment of taxes through credit cards, and whether or not you expand it again, this would be a matter for the Office of Tax and Revenue to decide what's feasible. I'm not sure, Professor Jello, maybe you have some information about other states that dealt with it in their tax laws.
You know, I don't, so I don't have anything to add. Thank you.
We'll ask around and see if we can find anything. We'll certainly let you know about how to handle it. But I mean, people, it's evolved as new forms of payments have evolved, becoming more and more efficient to use. For example, a credit card to pay your certain bills rather than cash or check. And who knows what the future will be. But we certainly are prepared for it. And this Uniform Commercial Code, which is an absolute essential to commerce in the country, the whole purpose of this bill is to update it and make it current and smoothly integrate with what's happening out there. So thank you very much.
Thank you. Thank you both for your testimony. And that will conclude my questions for this panel.
Thank you again.
Thank you. We'll now move on to our next agenda item. And we'll hear public witnesses for B25-456, Tenant and Rowhouse Short-Term Rental Clarification Amendment Act of 2023. We'll have one panel of public witnesses to include Lee Wells, Catalyn Peter, Larissa Wells, Ruth Whitaker, Chamber of Progress, Shalaka Joi, State Policy Coordinator of TechNet, and Vincent Feng, Public Policy Manager, Airbnb, Inc. Just give us a second while we invite everybody to join the panel. Remember, when you see your invite pop up, please accept it. Okay, we'll begin with Lee Wells. Lee, you may begin your testimony when you're ready.
Can you hear me?
Yes.
Oh, hello. Hello, my name is Lee Wells, and I'm a longtime DC resident. I would like to advocate for improvements to the short-term rental law, including further explicitly clarifying that houses in the RF zones with certificates of occupancy are eligible for short-term rentals. My husband and I worked very hard for many years to save up to buy a house in DC. When I bought and renovated my house over 5 years ago, DLCP's predecessor, DCRA, mandated that if you wanted to legally rent out your English basement, you must go through the certificate of occupancy process. Accessory dwelling units are not allowed in RF zones, which encompasses large portions of the city. You must go through the C of O process. At the time and up until this year, I had no idea of the difference, and I thought that I had built an ADU, as there was much talk of them at the time of renovating my house, to encourage more long and short-term housing. Renovating my home cost a lot more than I had anticipated because of the health and safety requirements of DCRA and the modern building code requirements, including adding sprinklers and fire separation. We should encourage such improvements to homes, and not passing this law will deter residents from improving their properties, improving the health and safety elements of their properties, as well as increasing the housing stock in the city. Excluding properties from short-term renting that look identical to other surrounding properties that didn't have to go through the same process as I did with the costly requirements of the modern building code does not make sense. My English basement looks identical to other properties without C of Os in my surrounding neighborhoods that currently are allowed to rent short-term, and I also meet the qualifications of what an ADU would be. I have one property ID tax record and one address. I had been a licensed by DLCP short-term host until this year, when DLCP decided to unilaterally remove my English basement from Airbnb. Becoming a short-term rental host was one of the great discoveries and joys of my life. Besides meeting visitors to our city, I was able to host family, friends, and neighbors' friends at my home. I was able to host my family for my parents' 50th wedding anniversary, host neighbors' families during the holidays, as well as children and their families coming in town for cancer treatment at Children's Hospital, amongst many other visitors I've enjoyed getting to know. Being an Airbnb superhost gave me a great sense of purpose and structure to my life. I took great satisfaction in welcoming people to our city and the positive experience in our nation's capital I helped create. DLCP took that job and joy away from me, even though I have a valid license and a safe and hospitable English basement. Hosting requires a great amount of work and is more important than ever in welcoming visitors and their tax dollars to our city. I need the flexibility that short-term rental law intended for residents to be able to host short-term visitors at my home, as well as friends and family when needed. I cannot do that with long-term tenants or stays greater than 30 days. I would also like to advocate for improvements to DLCP and oversight in regard to the short-term rental office. I found the process I went through to be a nightmare, especially for a homeowner going against a government agency. I have heard from other residents similar terrible encounters. While working with Councilmember Nadeau's office, they had told my lawyer that the matter was considered settled and did not allow any appeal process, but instead unilaterally removed my property from the platform without my constitutional right to appeal. When I talked to many attorneys across the city, as well as a senior Department of Building official whom had been involved in my matter, they too found that DLCP's interpretations to be misinformed, but that the agency also needs a clearer law. I and many others, including seemingly those at DLCP, find the short-term rental law very confusing, and it could be used further improvements to be less complicated, clearer, and easier to follow for lay people. Many residents have left the district during and after COVID for many reasons. As a real estate agent, I have seen and heard many residents grow tired of being harassed by government agencies, complicated laws, and a bureaucracy that is hard to navigate, especially when trying to do the right thing as a resident. The agency's behavior has unintended consequences that damage their reputation amongst residents and encourage residents not to engage with the agencies. DC is a very transient city, and we need short-term accommodations in our neighborhoods, as well as the tax dollars from visitors to our city to help fund the improvements and to solve our violent and petty crime across our city. More than ever, we depend on their economic impact to help improve our city. But more important than that, residents deserve flexibility and freedom to use their homes if they meet health and safety standards. Short-term rental hosts play an important role in the economic vitality and diversity of this city. I would like to thank Councilmember Nadeau and her office for spearheading this legislation and her office's help in dealing with DLCP. And I hope the council will consider other improvements beyond just those in this legislation to reduce friction, money, and time wasted dealing with disagreements with DLCP. This has been a huge financial burden and stressful time in my life, and I have been unable to host friends and family I wanted. And further improvements will lessen the time wasted in dealing with issues between agencies and council members' offices. Thank you.
Thank you very much. We'll turn now to Catalyn Peter.
Good morning, Chairperson Nadeau and members of the committee. My name is Catalyn Peter, and I am the Vice President of Government Affairs for the Apartment and Office Building Association. Our members are housing providers, and they operate, manage approximately 107,000 residential apartment units all throughout the district. My role today here is not necessarily to take a position on the overall place for short-term rentals in our communities. It is the perspective of housing providers and the tenants in their communities and the responsibility that they do have to all of the tenants in their communities. It is our understanding that this bill makes clarifications that would allow tenants in residential apartment communities to use their apartments for short-term rentals. As we have heard before, short-term rentals and the process of becoming a short-term rental host is a very, very, very great responsibility. Up until this point, it has been owners of individual properties who have been serving the role as hosts. For a tenant in a residential apartment community to take on this role, it requires a number of responsibilities on their part, and it also has an additional layer of risks, which we have understood to be outlined in the original short-term legislation, which can be a bit confusing in terms of whether or not what types of rights short-term rental guests have. What I want to focus on is our two main concerns. I do believe that they are addressed. I cannot emphasize and stress them enough in terms of how big a concern they are. First and foremost is that if a tenant and a housing provider expressly agree and go through the process of outlining in their lease that the tenant may be a host for short-term rentals, we do believe that they should be able to have that ability to contract. This is going to come back to a number of things that housing provider would have to outline because they also have an obligation to their other tenants and making sure that the community is safe, that it does not impose additional burdens to the other tenants in the community. So without such express permission and the way that this can be balanced to protect the other residents in the communities, we cannot support it unless there is absolutely express permission from the housing provider who has been able to balance the interests of their other residents. And then additionally, I think what many tenants may not even understand is how far their rights extend. We understand that the original short-term rental law does not extend additional protected tenant rights to short-term rental guests. We think that this needs to be expressly clarified within this legislation as well. Tenants are afforded very special rights in the district. They have, it is very particular to tenants. And if we were to extend those to short-term rental guests, it could cause a host of problems. So I know that the original bill clarified this. We want to ensure that this is something that is taken very seriously, and that original tenants are not stripped of any rights inadvertently through this legislation. I see that I'm over my time, so I will stop. We are happy to work with our colleagues at Airbnb and with the Committee on Public Works and in terms of these concerns. Thank you.
Thank you very much. Larissa Wells. Larissa hasn't joined yet. So then we will go next to Ruth Whitaker, Chamber of Progress.
Good morning. My name is Ruth Whitaker, and I am Policy Manager for the Chamber of Progress, a tech industry coalition committed to ensuring that all Americans benefit from technological leaps. Our corporate partners include companies like Airbnb, but our partners do not have a vote or veto over our positions. I'm here to urge the committee to support Bill 25-456, which would update the District of Columbia's Short-Term Rental Regulation Act of 2018 to expand short-term rental opportunities. Short-term rentals offer benefits for hosts and communities, such as increased access to affordable lodging options and supplemental income to support families in the city. They also encourage visitors to explore more of the city, bringing new customers to local businesses outside of popular tourist areas. By expanding the opportunity to operate a short-term rental to tenants and clarifying provisions related to the rental of basement and ground level units, this bill will ensure that the benefits of short-term rentals are more equitably distributed for DC residents. While the 2018 law was well-intentioned, certain provisions resulted in tenants who are more likely to be Black to be shut out of the opportunity to earn extra income from renting out their home. According to a report by the Urban Institute, by 2040, 55% of DC homeowners will be white, while 36% will be Black, a 17% increase for white homeowners since 1990, compared to only a 1% increase for Black homeowners. Extending eligibility for short-term rental permits to DC tenants will create new economic opportunities, particularly for communities that have been historically disadvantaged across DC. The 2018 law also allowed residents in residential zones to operate a short-term rental license and rent out their basement units, while denying licenses for residents in residential flat zones. As a result, a homeowner in Trinidad would be unable to rent out their basement unit, while a homeowner in Calorama with an identical home layout would be permitted to operate a short-term rental unit. By expanding short-term rentals into more neighborhoods, this bill encourages visitors and tourists to explore more of the city and local businesses. According to survey data, 92% of hosts provided recommendations for local restaurants and cafes, and guests reported that 41% of their overall trip spending occurred in the neighborhoods they stayed in. Amending the 2018 law with Bill 25-456 will ensure the benefits of short-term rentals are shared fairly throughout the city. We urge the committee to support this bill. Thank you.
Thank you very much for your testimony. Next, we'll hear from Shalaka Joi, State Policy Coordinator with TechNet.
Good morning, everyone. My name is Shalaka Joi. I am the State Policy Coordinator at TechNet, a technology trade association. I'm here in place of Margaret Durkin, TechNet's Mid-Atlantic Executive Director, who is unable to testify today. TechNet is a trade association that represents over 4.5 million employees and customers in the fields of information technology, e-commerce, and the sharing economy, amongst several others. Thank you today for the opportunity to speak on the Tenant and Rowhouse Short-Term Rental Clarification Amendment Act of 2023. The sharing economy is creating new jobs and income opportunities in every corner of the country, allowing people to work independently and on discretionary schedules, use their personal property and skills to generate income, help them expand their businesses, and provide for themselves and their families. Policymakers should ensure that efforts to regulate the sharing economy protect innovation and individual empowerment and are not overly burdensome, and to recognize the unique nature of the sharing economy when compared to traditional providers. TechNet supports this bill as a way to bring fairness to the citizen-led digital tourism economy by allowing those who haven't been able to purchase a home to share their rentals and make additional income with permission from their landlord. Currently, DC statute mandates that a consumer must own a home or apartment to be able to list a property as a short-term rental. Many district residents rent while also traveling for both professional and personal reasons. TechNet believes that all consumers should be afforded the opportunity to participate in the sharing economy, regardless of home ownership status. Many major cities already allow tenants to get a short-term rental permit. Those include, but are not limited to, Atlanta, Charlotte, Dallas, Los Angeles, Miami, Pittsburgh, Portland, Sacramento, San Diego, and Tampa. This bill also supports the housing needs of the remote work economy of short and medium-term workers in DC who bring dollars into neighborhoods across the city. By allowing renters to list their space on a rental platform, the district can provide additional and varied housing options to those visiting for short and long-term stays. Furthermore, the increased capacity will draw more commerce into the district, ultimately benefiting businesses and residents. TechNet is committed to expanding access to the sharing economy and thanks you for your consideration and support of this issue. TechNet and its members hope to align DC with other areas that do allow for tenant-host equity. We look forward to continuing these discussions with you. Thank you very much.
Thank you for your testimony. Next, we'll hear from Vincent Feng, Public Policy Manager at Airbnb.
Good morning, Chairperson Nadeau and committee staff. My name is Vincent Feng, and I'm a Public Policy Manager at Airbnb and a 27-year resident of Ward 3, of the district, currently residing in Ward 3. On behalf of Airbnb, thank you for the opportunity to testify in support of Bill 25-0456, the Tenant and Rowhouse Short-Term Rental Amendment Act of 2023. Airbnb is a leading online marketplace created 15 years ago by 3 tenant roommates, focused on providing a platform for users to list and book unique accommodations and experiences in Washington, D.C. and around the world. Airbnb supports Bill 25-0456, which addresses deficiencies in the Short-Term Rental Regulation Act of 2018 that have resulted in inequities between and amongst tenants and homeowners in the district. Without this legislation, tenants, even with landlord approval, are no longer able to obtain short-term rental licenses and become hosts. This is because the current law requires that the primary residency requirement be shown through eligibility for the DC homestead tax deduction, which can only be obtained if you own the property. This definition has had the effect of blocking tenants who are nonetheless capable of demonstrating primary residency through other means from an economic opportunity that is being provided to homeowners. This is especially problematic in the district where tenants make up more than half the residents. Moreover, tenants stand to benefit greatly from this economic opportunity. Additional income for tenants could be the difference between being able to pay to stay in the district and having to move out to neighboring cities. Looking further, it could also help tenants one day afford to become homeowners by lessening the burden of their ever-increasing rent prices. On the district level, passing this legislation would increase revenue not only by putting money in the pockets of residents, but by increasing the number of visitors who travel to DC and spend their money on local businesses. In an estimate provided by DCLP during the 2023 budget oversight hearing, DCLP stated that there were around 2,700 active licenses. DCLP then went on to state that the estimate it had for active licenses prior to the regulations being that removed tenants was around 7,000 to 9,000. Therefore, the bill has the potential to have an immense positive effect on the district's economy, especially at a time where the district's projected revenue is a topic of concern. Guests of tenants would pay the same 15.95% in DC sales tax and hotel tax that all short-term rental guests have paid in the district since 2015. In 2022, Airbnb remitted to OTR approximately $17.5 million in taxes from our guests. Additionally, the legislation would address inequity that exists between homeowners. As you know, the district is home to many row houses, and it's very common for them to have a basement unit. However, these row houses are classified differently depending on the residential zone. Finally, on behalf of Airbnb, I'd like to applaud Councilmember Nadeau and the committee for their careful consideration of issues of tenant and homeowners are facing under the current STR laws. We believe the bill squarely corresponds to and rectifies the deficiencies that our users have been battling ever since the current regulations came into effect. We look forward to continuing to work with the district serving its residents, and I thank you for this opportunity to testify, and I'm happy to answer any questions you have. Thank you.
Thank you very much for your testimony. Mr. Wells, can you talk more in detail about the back and forth you had with DLCP in this process and what the timeline for that was?
Sure. I had tried to renew my C of O during when DCRA was splitting into two organizations, and had tried to communicate and get a fee waived because DCRA had not notified me that my C of O was expiring. And at that time, the short-term rental office gave me an infraction. And so that started in January. I had been reaching out and talking to your office and said, you know, I would like to deal with this administratively, but if not, then I would like to appeal. I guess that's how it developed. And then in May, they removed my Airbnb from the platform without notice. And they also removed the infraction and said I couldn't appeal. So I guess one of the other things is they should have issued another infraction according to my lawyer. But they did not. So it was very unclear in terms of the communications.
And what are the limitations of having a vacation rental license as opposed to a short-term rental license?
So with the vacation rental license, it's my understanding that you're only allowed to rent 90 days per year. And then after that, you have to have stays of greater than 30 days. And so since May, I've had a vacation rental license on my English basement, and I've had long periods of vacancy, as well as, you know, if I wanted to host family at the beginning of, I don't know, December, you know, I have to plan around that 30-day stays. And so, you know, from a city perspective, during those days of vacancy, you're losing out on tax dollars of the hotel occupancy tax. But also as a homeowner, it's just extremely stressful to manage that, especially when I have friends or family that I want to stay in my English basement.
And what was the impact to your revenue from the change to a vacation rental?
It was major. It was a huge economic impact to me, and has been very stressful since the end of May.
Could you quantify it?
I would say, I guess probably, let me think about this, $50,000 this year.
Thank you. And I'll open this one up to anybody on the panel. Are there other changes to the short-term rental law anyone recommends beyond what's in this legislation?
I guess I would like to say a couple things. I did also, when I did get an infraction, they had said that that my Airbnb, the occupancy was over the limit. They said that only 4 were allowed. But when I read the law, it says that you can have 2 per bedroom or up to 8, whichever amount is greater. And I find that in terms of they need clarification, I guess, in the law. I don't know, but the way that I read the law, I just have a sofa bed in my living room, and I often find families need accommodations for their young ones, and they all want to be in one unit instead of multiple hotel rooms. So if there could be clarification with DLCP that you're allowed to have a sofa bed, and that, you know, if 2 young children want to sleep on it, that should be something. I think there is also a discrepancy between the vacation and short-term rental office in terms of which licenses you need and when you're on the premises. That could be further clarified.
Councilmember Nadeau, if I may, I don't see in this particular legislation something that really makes abundantly clear that the tenant, the original tenant, the lease holding tenant, holds on to, has tenant rights. we are we are very anxious about any confusion between who ultimately holds those tenant rights, whether it is we often, I mean, we've had cases with a lot of cases with regards to synthetic fraud recently, and that's where my spider senses are really coming in, because once you do establish, trying to think of the right word, I feel you understand where I'm coming from, to ensure that the leaseholder, the correct leaseholder holds established tenant rights.
Yes, understood. And then you had raised another concern. I'm curious about generally with your members. I mean, do most of them have lease agreements that prohibit short-term rental?
I do not know the extent to that. I mean, my understanding is right now, because you have to be the owner to be able to do short-term rentals, whether or not the lease would even need to prohibit it, I don't know. But I think we would want to make abundantly clear that yes, a lease is able to expressly prohibit that. I mean, theoretically, if you have to have the express written permission of the landlord to operate a short-term rental, that might be somewhat moot. Because if you can't get that, then you won't be given a license. I think that in particular now, you have so many communities where it's not just a matter of, one. I think there's a difference between smaller housing providers, single unit providers, and whereas our members have hundreds of tenants who may, who you have to balance those interests in terms of tenants being able to utilize it for short-term rentals.
Yeah, I mean, certainly the way it's drafted, the requirement is that the landlord is required to give permission.
Yeah. I mean, I'm still, and I've spoken to colleagues at Airbnb. We still have members who are concerned in that, to what extent, right? I mean, to what extent, I think that, what type of information does the housing provider have on, who's coming into the building as a short term? I mean, ultimately, it's the housing provider that has, full responsibility for this. So this is a very major thing that they would be, if they would give permission to, it's yeah.
Do you have any members right now who run short-term rentals in their multifamily buildings?
I believe that there are, it's not very prevalent. I believe that there are a few who particularly may have been struggling with a greater number of vacancies, who have allowed for certain units to be utilized as short-term rentals. I don't believe it's a lot. I don't believe it's a lot. But I do think there are a few. And my guess is there are probably smaller housing providers who do utilize. I think there are probably a lot of providers in the 4 or less unit space that do utilize. I mean, I think that there are, frankly, I mean, that was the original, when we had the original public policy debate on whether or not, having buildings utilized as short-term rentals versus buildings for long-term tenants. And that's the greater policy discussion that was surrounding this. Yes.
Right.
Yeah.
Yep.
Yeah.
Absolutely.
Yeah.
Okay. Let's see. And Miss Joshi, you mentioned other cities that allow for tenant hosts. Are there laws governing tenant short-term rental listings similar to what's in this bill?
Yes, the cities I mentioned are places where they already allow those who are renters to also be able to put their to participate in the short-term rental economy. And I would be happy to provide the committee with more information on this offline as well. And so we hope that by moving this legislation forward, that the district can also align with other cities in this regard and allow the residents here to also be able to participate in this way. Thank you.
Do those cities similarly require that the owner of the property approves the tenant rental?
I'm not exactly familiar with that detail, but I would be happy to provide that information to the committee offline.
Okay. And do you have any data on the economic impact of tenants from the additional income stream?
I do not have that data at this moment, but that is also something that I would be happy to provide to you separately.
Sure.
Thank you.
And if there's anyone else on the panel who has any data on economic impact of tenants, welcome that as well. And Ms. Peter had mentioned some of the intent of the original bill and our goal of protecting the overall rental market. And that was certainly a major motivation of the initial legislation. Are any folks here concerned about about this bill potentially impacting the overall rental market? I want to move to, do we have one more panelist? Okay.
I would be curious, Councilmember Moreno, to work with our colleagues at Airbnb to see what any sort of information on. I mean, I think that's a good question. I'll leave it at that. I think it's a good question and something we should all consider.
Councilmember, may I make a comment at all about the?
Yeah, go ahead. And I have a couple questions for you as well.
Thank you. Regarding the issue of landlord permissions as well as long-term tenant rights, I fully understand the potential concerns from our friends at the Apartment Owner Office Building Association, and appreciate their support for the bill with those provisions in it. I just wanted to note that surrounding communities of Washington do have tenant rights for short-term rentals. Montgomery County, Maryland, Arlington County, Virginia, and Alexandria County, also in Virginia, as we all know, as well as up in Baltimore County. And all of those counties and their respective regulatory licensing jurisdictions require landlord permission to be part of the application. And that's what we would support here as well and applaud in the bill, is that this simply states that you have to provide that letter of permission from the landlord, as well as your lease, which allows you to show your residency as a resident of the district. I would also say that we have tenants who are short-term rental hosts throughout the country and have never experienced yet anything of note regarding overstays or people exercising traditional tenant rights. And that includes cities that have even stronger tenant laws than the district. San Francisco, for example, Los Angeles, California, Portland, Oregon, Sacramento, all places that also have strong tenant rights. And we've not seen any tenant hosts have guests that have exercised traditional tenant rights for short-term stays. So thank you for letting me share those data points.
Sure, absolutely. So you'd given testimony that there were anywhere between 4,000 to 6,000 fewer listings now than there were before the law took effect. Do you know how many of those were attributable to rental tenants? Because one of the things we were trying to crack down on was whole home rentals by, as full investment properties. And I'm sure some of those also came off the rolls.
Sure. I don't have that data right here, but I think it's approximately somewhere around 500. And then the larger number were individuals who didn't have a path to qualify for a short-term rental license due to residency requirement.
Mm-hmm. And are there elements to your terms of service that govern tenants?
I would have to get back to you on that because I'm not knowledgeable to answer that question, but I'm generally, I would say our terms of service cover any host, and we see all hosts, whether they own the home or they're a tenant, um, as a host. And again, I mean, that's why we applaud the technical change here, is that we see how the district and the council wanted to move forward to create a very strong way to prove residency, right, through the homeowner tax deduction, and understand that. And I think from our conversations with other individuals in the council, it sounded like it was tenants being removed from eligibility was not intended. It was an unfortunate way, consequence of using the tax deduction as the document. So, but thank you for letting me expound on that.
Yeah. So we have some very specific requirements in the bill as introduced for tenant verification. How much of this do you think is warranted versus should be left to private agreements between tenant and landlord?
Well, I think I think it would be not possible. I think the testimony, I think if you were alluding to, I did see testimony that was submitted in writing for the public from DCLP this morning stating that could be a case. Unfortunately, that would not be the case. The law, the way it's written, specifically says that you have to actually, excuse me, let's start over. So with respect to that idea, that interpretation that I saw from DCLP, if you referred to it, that a tenant could create an arrangement with an owner of the property to manage the unit as a short-term rental is not accurate. If there was a tenant in the property would not be eligible for the homestead deduction, right? So therefore, there would never be an opportunity for the tenant to create that arrangement with the landowner, because the landowner would not be, under the law, be able to provide DCLP that homeowner tax deduction to actually get the licenses at all for that unit.
I guess it might in some cases with the English basement though.
Yeah, that confused me a bit too.
Okay, we can talk more about it with DLCP. Mr. Ferlici, how do you communicate local laws and regulations to your users? Hosts?
Quite a bit. I was in charge of all communication with all hosts over this when the regulations came out in December/January of 2022, and then when the actual enforcement started in June. Between January and June, between the regulations coming out from DCRA at that point to when the actual enforcement date went into effect, we sent out over 12 communications to our hosts, explaining the new laws, explaining that without getting their permit through DCRA, that they would have their listing taken down. And then, of course, in June, when the enforcement went into effect, we then removed all the listings that had not provided their listing number that they had gotten from DCRA. In fact, we communicated so much with them during the process of onboarding folks to the new law that we learned that many of them were so afraid that they were going to be taken down come May because they had not gotten their clean hands letter from OTR, which is also part of the process that has to be presented to DCLP in order to get a license, which was unfortunate. And that was because the law went into effect in and around the same time as tax season, and OTR was backed up with its court function. We were very happy that the council passed emergency legislation, thanks to Chair Mendelson, to provide an extension for folks for that process. So very heavily speak with our hosts, and we have a responsible hosting page that anyone can Google, Airbnb DC responsible hosting, that tells people about how to host in DC. And then of course we work very closely with DCLP. I probably share communications with DCLP and their director of short-term rentals at least once a week regarding listings that are out of compliance and need to be removed. And then we communicate with the hosts if there's any issues with that. But it's a very robust communication, not only between us and our hosts about the laws, but with our regulator, the DCLP.
Thank you. One minor component of this bill would require platforms to clearly show the license information of each listing. Do you have any issue with that provision?
We don't, because the 2018 law still requires that, and we do that now. And without that, no listing can be listed in the district, regardless of what kind of listing it is.
Ms. Peter, should there be any consideration of what the default arrangement should be between a landlord and tenant? And by that, I mean, if short-term rental is not mentioned in a lease, should it be presumed allowed or forbidden?
I would venture to say may I put that in writing?
Yep.
Thank you.
All right. Thank you to this panel. I appreciate your testimony. We had one additional witness join for, we'll just make this our final panel for this bill, Finita Dilworth. Ms. Dilworth, you may begin your testimony.
Hello, I actually think they covered everything that I wanted to talk about in my testimony, but thank you for the opportunity anyway to provide. My name is Finita Dilworth. I live in Ward 8, Washington, D.C. I'm a business owner and a former short-term rental until the renters were disallowed. I'm not a homeowner. I am a renter. I'm here today related to this short-term listing, the difficulty in obtaining a license and the exclusion of renters from obtaining homestead statute required to secure the short-term rental license. I began hosting in 2016. Hosting on the platform has been my primary source of income for over 7 years. And I have been before this committee every single time to appeal this ruling. Prior to the current legislation, I welcomed guests from around the world and offered a super host experience in my home here in Ward 8. So I'd like to offer 3 points to this committee. Could you consider, and people have already talked about this, could you consider the process of obtaining a license more seamless? It's extremely difficult. Could you consider to be inclusive and allow all the citizens who can and are willing to host on the short-term rental platform, can you allow them to do so? As you know, renters are excluded from hosting. Not every citizen in Washington, D.C. can afford the high cost of home ownership. And as one of the other witnesses stated, and for Black Americans in D.C., the number is even smaller than that. In Washington, D.C., can we afford the high cost of home ownership? And we should be included into the economic opportunities available in the short-term rentals. And could you consider the economic impact of a long-term host as myself, who are now struggling to recover from the loss of income as a result of this current legislation? And I'd really just appeal to this committee to just allow renters to participate in this economic opportunity. I thank you for your time.
Thank you so much. I have just a question for you, just so we can understand your experience. What was your relationship with your landlord or property manager when you were hosting? Did you encounter any issues?
I did not. I live in a 6-unit apartment building. My landlord was unable to actually rent a couple of the apartments. I asked him if he would let me rent one of the apartments in addition to my own personal apartment. So in the 6-unit apartment building, I was responsible for 2 of the units, the one I live in and another one that I hosted for Airbnb. I also hosted, it's a 2-bedroom apartment. I hosted one of the rooms in my home, and that helped me to make ends meet. My landlord was open to it. He was open to the sharing of it. He was open to me maintaining the care and quality of the building, because I always made sure that as I live in Ward 8 and sometimes the street, I don't get the same facility street cleaning as other wards may get. So I was able to kind of step up as the property manager. So my landlord loved that I maintained the quality of the building in which we all live and enjoy. But my landlord was in full agreement of the situation. Thank you.
Okay, thank you very much for your testimony.
Thank you for having me.
We'll now turn to our government witness. Tiffany Crow, Acting Director of the Department of Licensing and Consumer Protection. Welcome. Before you begin your testimony, I'm going to have you swear the oath, raise your right hand and turn on your microphone. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Great, thank you. You may begin your testimony.
Good morning, Chairperson Nadeau, committee members, and staff. Thank you for having me. I'm Tiffany Crow, Acting Director of the Department of Licensing and Consumer Protection. I'm here today to testify regarding Bill 25-0456, the Tenant and Rowhouse Short-Term Rental Clarification Amendment Act of 2023, which extends licensure to tenants who verify primary residency and attempts to clarify limitations on multi-unit properties. DLCP appreciates the Council's efforts to support the economic mobility of district residents and businesses. We are concerned, however, that the amendments as proposed may actually frustrate this purpose, create undue administrative burden, and further reduce housing stock and undermine the original intent of the Short-Term Rental Regulation Act of 2018. The short-term rental license categories, which include short-term rental license and short-term rental vacation license, were created in 2019 and, as written, allow anyone to apply for an STR license for their primary residence. Since December 2021, we have issued more than 3,000 short-term rental licenses of both types and have partnered with OTR to verify primary residence status for each of those. We believe this structure should remain in place and that property owners can use the contracts they already have in place with their tenants to support alternative uses for their units. The agency recognizes the committee's intent to clarify the provision related to the owner of a 2-unit property in a residential flat zone and acknowledges having previously interpreted this to limit a property owner's use of a verified primary residence. DLCP supports the current interpretation that the primary resident of a multi-unit property located anywhere in the district is eligible for an STR license. In the interest of transparency, the agency will clarify its posture related to this provision moving forward on our website and in any supportive materials where this may have been confusing. We do not believe that additional legislation is necessary to codify this particular clarification. Rather, the amendment unnecessarily and inappropriately introduces government regulation into what should remain a private agreement between the parties and opens the door for fraud by bad actors intending to turn ineligible units into eligible ones through the guise of tenant rentals. The terms of any agreement to manage or operate an STR should remain between the parties involved, the property owner, tenant, property management company, and the hosting platform. Allowing a tenant to apply for a license independently puts the burden on DLCP to verify that the property owner has given permission to operate an STR and with all of the associated risks that entails. Without access to private landlord-tenant information, DLCP could not verify any permission provided by an applicant. Even if the agency had irrefutable evidence of the property owner's approval, the proposed amendments also require DLCP to track and take action upon termination of any lease agreement associated with an STR license, further involving the agency in agreements between a landlord and a tenant. Instead, the agency proposes that any license for an STR continue to be associated with a natural person's primary residence as verified by eligibility for homestead deduction. A tenant may, however, enter into a private arrangement with their landlord to manage a property as an STR, much as they would agree to sublet a property. The agency will be able to continue its enforcement of unlicensed rentals by checking on platforms and verifying property ownership based on publicly available property information. The property owner will be able to ensure that a tenant is complying with the terms of any lease or agreement without having to be concerned that a tenant has been able to obtain a license for an unauthorized use of the property. As we move forward and gather more data about how this industry is evolving in the District of Columbia, the agency is open to considering future amendments to the short-term rental regulations. I'm happy that Airbnb and the witnesses, the public witnesses testified today, and want to emphasize that we will continue at DLCP to work with the hosting platforms, advocates, hosts, and members of the public to ensure that economic opportunities are expanded with prudent considerations for necessary oversight in the interest of the district. This includes continuing to monitor for any misuse by property investors and keeping an open mind for how we can improve the program and experiences of its users through such methods as increasing transparency by having active licenses verified by the platform or the rental customer before a booking can be made. I would like to thank the committee again for allowing me to testify. Your ongoing efforts are vital to the city, and as the newly appointed acting director of DLCP, I look forward to working more closely to ensure that we are supporting the economic well-being of our city.
Thank you very much for your testimony. And thank you for your commitment to rectifying DLCP's interpretation of the law with regard to properties in RF zones. Do you have any objection to council amending the language in statute to make it sure it's 100% clear?
No, I think we would be willing to participate in that. I would love to work together to make sure that we understand sort of what amendments would be made.
Yep, no problem. In your view, is the distinction between a short-term rental license and a vacation rental license meaningful enough to be worthy having both categories?
I think right now, so if you look at the volume of rental licenses, most people have opted for the short-term rental license. And I think it's because the cap, that 90-day cap is associated primarily with the vacation rental.
Mhm.
And so, you know, if it's your primary residence, then you have the ability to make more money using the short term. So I think in the law, there's a meaningful difference. And that is the reason, my guess is, for the volume between the two. Also, when you're doing the vacation rental license, you don't have to be on premises, so you can rent out your whole property. And when you're doing the short term rental license, you have to be on premises during this day. There are meaningful differences in the law to answer your question. I think in practice, I'm not sure yet. So
Yeah, fair. But that's helpful to know, just sort of the volume and your thinking behind why that might be. Okay, so I want to talk a bit about tenants, and I understand your concern about DLCP being inserted between multiple private parties, especially when you don't have easy access to housing records. You suggest that a tenant could enter into a private agreement with their landlord to manage a property as a short-term rental. Is that already possible under the current law, or would it require changes?
No, it's already possible. And actually, I was listening to all the testimony, furiously writing, right? Because I heard several times people say that the current law, excludes tenants, it forbids it, and it doesn't.
Mhm.
Explicitly, it does not exclude tenants. What it does, though, is require that the license holder be the owner of the property. So the point about the homestead deduction being the way that we verify residency is accurate, but the entirety of the law requires that the person holding the license be the resident of the property. So this doesn't make that worse. It just explicitly puts in a law that tenants can rent and adds the government in there. So
I think that one of the challenges with it is that we're using the homestead deduction. And if you are a tenant who uses the entire house, for example, then there wouldn't be a homestead deduction on it. So that becomes right. So
Yes.
your landlord in theory could apply for that license, but then you would not make it through the process because you couldn't demonstrate you had a homestead deduction.
So the landlord, in that scenario, the landlord could not apply for short-term rental or vacation license because it's not their primary residence.
Right.
So if they are claiming the homestead deduction, then
That's a problem.
they have a problem with a different agency. And so I think, well, in further conversations about amendments to the law, right? So I think there are scenarios where people who used to live in the district move and then they want to rent their entire home out, which they absolutely have the right to as the homeowner. It's just that the law as currently written is not intended for those individuals to do the short-term rental because of the concerns on the permanent housing stock.
Right. So for example, there's a gentleman who lives on Fairmont Street Northwest. He's rented his house there for 30 years. Before we passed the law in 2018, he rented a room in his house. Now he can't do that. The law doesn't allow it at all. We'd have to change the law to allow that, right?
That's right.
Okay. So in that scenario, they couldn't just enter into a private arrangement with the landlord to manage the property as a short-term rental, right?
Right.
Yeah. So what you're talking about is probably more when you have an accessory dwelling unit and someone, the main property owner lives upstairs, there's a tenant in the basement, and with a private arrangement, that tenant could do short-term rental because there is a homestead deduction on that property.
So that scenario would apply, or the scenario where there is a 4-unit property and the owner actually resides in one of the units, they could do short-term rental vacation license on those properties. I think the 2 areas mentioned today where there would need to be a change to the law are the one where it is not the primary residence of the actual property owner. And then if the unit is 5 or more, I think. So
Okay. So part of the philosophy here is to provide tenants with a similar wealth building opportunity that homeowners have. We've talked about this. I know we both are interested in that aspect of it. I'd be concerned that leaving it entirely up to private arrangements would make tenants property managers or instrumentalities of their landlord rather than it being their own income stream. Do you have any suggestions on how to address that?
yes, so actually one of the things that Airbnb has done in those cities, because we did research on how it's working in other cities. And, there are varying sort of results. It's difficult to find the economic impact data on whether or not it has impacted the number of bookings and the wealth building of those communities. But in many scenarios, the property owner does take a cut of what the tenant is receiving, primarily when it comes to Airbnb as a hosting site. But what we would want to do is figure out a way that in those private agreements, there's no sort of requirement that there be a cut going to the property owner. In every scenario, even with these amendments, without an amendment, that agreement has to be between the tenant and the property owner because they have to give it express permission, even with the amendments proposed. And so I think prevention of sort of abuse, maybe
Mhm.
there's some legislation that could happen there. Like maybe there's a max percentage that a property owner could charge for permission, especially if they have to do the administrative portion of getting the license. So, I mean, we definitely are thinking about it because we do want tenants to be able to build wealth in the district. I think it's currently like 60-40 renters to owners.
Right, exactly. Okay. Same question I asked the panel. Should there be any consideration of what the default arrangement should be between a landlord and tenant? And by that, I mean, if short-term rental is not mentioned in a lease, should it be presumed allowed or forbidden?
I think currently, if you're talking about sublets, if it's not explicitly allowed, I think the default is forbidden. And so that presumption may extend to short-term rentals, but I would need to do research on how it's working in other jurisdictions, sort of some of the challenges. We have a list of like red flags from areas where it is in place now that we're kind of looking out for just in case.
Oh, interesting. Anything that you'd want to share right now on that?
Verification of permission.
Mhm.
So how occupants, like short-term occupants, are screened, who's responsible for property damage, if there are damages, the insurance question that one of the previous witnesses mentioned. So sort of all of the things that surround contracts, private contracts, who's responsible when something goes wrong,
Right.
right? If everything is going smoothly, normally there's no issue, but when there is an issue, right? So here you're adding so many layers. Like you have the hosting sites, you have the actual renters, you have the hosts, you have the property owner. And so for every layer that you add, there's a little complexity of who's actually responsible.
Yeah. I guess, you're thinking that the subletting might be a good thing for us to look at in terms of what's already widely held.
I think maybe it might worry the witness from the apartment association to do that because of the insurance sort of implications. But I think sometimes in our interest in trying to help, we kind of make it a little bit more complicated. And, my concerns as the new acting director are also operational, right? So when I heard the first witness, Mr. Wells, mention that his experience was bad, he got different answers, he had some issues with the process. We want to improve that too.
Right.
And so adding additional administrative challenges at this time, it might not be the right answer.
Okay. Is there a public data platform for a short-term rental system? If you're someone looking for a short-term rental, what assurance can we provide they're booking something that's fully licensed and legitimate?
Well, so actually, this is one thing that I know that the team predating me has been trying to get an agreement with the host sites to post the license numbers and verify the license numbers before posting the booking. That is a way that both the person seeking a site and the hosts can maintain their sort of, hey, I'm a verified host. So to answer your question, that is one way that we could ensure that. I don't think that we don't have a like single platform owned by the government to my knowledge at this time. So they'll correct me if I'm wrong.
Do we have any info on how many bookings our licensed rentals are getting? Or do you think that's data we should require from the industry?
So I think if we make adjustments in this way for equity and things like that, I think it would be useful information because we could really see the impact that legislation is having on the economic well-being of people who have this. So Mr. Wells indicated that he's lost $50,000 this year based on this. And, that's an astronomical number for a lot of people to even earn $50,000, right? So to lose that through this process, I think The last witness, she mentioned that this is her primary source of income, which most people would be surprised at the amount of money that you can make doing this. So I would love to have that data. We've been looking for it actually, so.
Noted. Beyond what's in this bill, we've heard from witnesses that the overall process of getting licensed can be onerous. Are there other reforms we should consider to streamline that process?
I'm still evaluating that, mainly because I'm learning how the process is working right now, what makes it onerous. There's an online form. We've actually, the second week, I think that I was on the job, we met with the vendor that supports the platform. And the team had a list of things that they had been asking them to do to make the process easier. And so now those are done.
Great.
But it's things like that. So we'll evaluate kind of how we can improve the process, improve the customer experience, because anything that we license should absolutely be easy, should be a pleasant experience for people. And that means strengthening our partnership with agencies like OTR and others.
Can you elaborate on your concern about expanding host eligibility having an impact on the rental market?
So the example of someone who doesn't live in the district any longer or isn't using a particular property as their primary residence, then being able to rent it long-term or do short-term, that is one less place for someone to live. And also, everyone who has worked hard and earned money has the right to do with their property as they see fit. But we also want to make sure that we're bolstering the economy of the district. And so I think my main concern is that the more we allow people to use the rental process to just build wealth rather than also thinking about the housing opportunities, we run that risk. So.
Research appears to show that there can be impacts on availability of units and rent prices, but that they're much more hyper localized to high demand neighborhoods for short-term rentals. Here's a quote from a University of Maryland study in 2019. Effects vary greatly by zip code, with mild increases in property prices across the board and spikes in tourist heavy locations like Georgetown, DuPont Circle, and Adams Morgan. Do we have enough data to pinpoint where in the district short-term rentals might be putting pressure on the market?
I don't yet. I don't know the answer to that. I can tell you which zip codes have the highest number of renters versus homeowners. And my guess is that they're not the same.
Right.
So
right.
I don't know that, but it's a great question.
Right. I mean, categorically, I guess they wouldn't be the same because they have to be homeowners to do this. So it'd be kind of the opposite. Interesting. Well, we'll see what we can do about getting some of that data. What kind of outreach is there to guide prospective hosts through the process of becoming licensed? Can there be resources for tenants on how to become hosts themselves if we move forward?
Yeah, so if you move forward with these amendments, there would have to be resources for tenants. And I'm not sure what that would look like, since the most onerous part of this would be written sort of proof of your residence, written proof that you have the permission of the owner, then sort of a mechanism for letting us know when your lease is up. And I'm just not sure right now that that would be the best use of our resources with so many of the other things that we are prioritizing, but we would do it, right? If there was a need to educate the public on how to do this, we would 100% do it. I think putting that on the property owners who currently have the responsibility to do it, but providing more support for property owners too. I heard a few people on here say that it's onerous for owners. So we would want to improve that.
Okay. Anything else you want to add?
I don't think so. We will take note of the request for data, and if it's data that we have or should have, we'll provide it.
Great. We'll see you back here after the next bill.
Okay, thank you so much.
Thank you so much.
Thank you for having me.
All right, we'll now move to public witnesses for Bill 25-151, Open Movie Captioning Requirement Act of 2023. Our first panel includes Brianne Berger with Deaf in Government Eric Nordloff, founder and lead organizer of DC Deaf Moviegoers and Allies. Tawny Holmes Bleibach, executive director, Conference of Educational Administrators of Schools and Programs for the Deaf. J. Eugenio Ravello, vice president, District of Columbia Association of the Deaf. And Russell Mishaloff, public witness. Great. Ms. Berger, you may begin when you're ready.
I'm not sure if you said my name or someone else first.
We
Okay.
will have Brienne Berger first, and then you will be next.
Okay, I'm sorry, I don't have my transcript ready. I thought that I was number 12. So one moment, please. I'm so sorry.
No problem. We'll wait.
I wasn't ready. I'm sorry. Okay, I'm so sorry.
No problem. I know we changed the order up a little bit. So when you're ready, we will be ready.
Okay. Okay, so I'm ready now.
Go ahead.
Okay, hello. My name is Brienne Berger. I'm a resident of DC for 19 years. I enjoy going to the movie theater like everyone else. I have many stories of, issues with special events that require setting up the computer or putting the glasses on my face. And I don't know why people are having to suffer to put the dirty glasses, from other strangers, other consumers' faces to my eyes, especially now with having COVID and other additional concerns. Many times the negative experiences with equipment, not working, or it consistently failing to turn on by the theater employees. It really requires a lot of maintenance, requires a lot of attention, and I have to inform the employees that I'm having issues, and what they do is just give me a ticket voucher to go back at another time. Well, many movie theaters do not provide any complaint process to make a formal application to this missing of valuable information at the theater, and they, there should be an alliance with both. So again, those devices, that the poles or the glasses, are required some time of maintenance. There's a cost and training the employees, and many movie theaters have a high turnover in employees. So there's always some type of training issue that results in broken or devices that aren't maintained, replaced, which could be easily resolved with just having the open captionings that requires no maintenance, no cost. That's it. Just giving the pay to the paying customers to have the option to come another time costs the movie theater money, and also running the risk that the theater loses that customer forever. So in addition, it provides the movie theater, the owner, the limit number of devices to service a small number of attendants. So if a lot of people do attend, then there's not enough devices for the consumers. But open captioning allows the full capacity of the movie theater. So the movie theaters will only instruct the number of paying customers to get the tickets, not the number of people who walk out of the movie theater before the end of the movie, or the number of vouchers provided to return another time. they're not recorded. So devices cost movie theaters hundred thousands of dollars a year. Open captioning only cost a movie theater zero, nothing. So the movie theater captioned by, to show the movie theater that all it costs is for them to use is to turn on the option in the software. That's it, for a little bit of training for this. Because of my consistent frustration and lack of confidence in this to work, I always attend the open captioning movie theaters only. That's it. This bill is very critical, reasonable, and it requires only a few open caption, demonstrations that shows multiple times during instruction. The theater often argue that the general public is not going to like the captioning and that possibly refuse to attend those shows. But since the ADA, American with Disabilities Act, passed in 1990, several categories of many generations have grown up living with some type of captioning on their television. So the public is far more accepting of captioning currently after COVID, especially. So every open captioned movie that I've attended, there's always crowds of hearing people who want the captionings on also. And I look around everywhere, the deaf and hearing audience, they want that. So Avalon on Ann Avenue, they have a high demand requesting open captioning movies so that they set up their schedule for the movies to have a large audience for hearing people who want the captioning on. This bill also includes the activity that's different than the legislature in both Hawaii and New York. This outreach activity will ensure that the attendance to open captioned shows is increasing and will be robust. That is why this bill will be successful and will end with that I am a mother of 2 hearing daughters who love to go to the movie theater together to spend quality time, and me and my kids don't want to be embarrassed that I have to use this device and then, stand out. But if you could please help my daughters feel equal to everyone else and provide an open caption on the screen for everyone to enjoy. So not only that, but I have section 4, and I don't want to feel limited because of watching only this, but I want to be able to watch a movie all over the town. Thank you so much. And please support this bill.
Thank you so much for your testimony. Next, we'll hear from Eric Nordloff, founder and lead organizer, DC Deaf Moviegoers and Allies.
Hi, can you hear me?
Yes.
Okay. All right, I'll get started. All right. Hello, Council members, and thank you for having this hearing for the Open Caption Movie Requirement Act of 2023. My name is Eric Nordloff, and I am the founder of DC Deaf Moviegoers and Allies, through which we request and share about open caption movie times in the Washington, D.C. area. I started DC Deaf Moviegoers in 2015 because I was fed up with years of problems with closed captioning devices. These negative experiences are universally shared across the deaf and hard of hearing community. These problems are still ongoing. The closed captioning devices continue to malfunction by dropping lines of dialogue repeatedly with their batteries being depleted. To draw a comparison, imagine yourself going to a movie theater where during a movie, entire bits of audio drop out entirely. You lose immersion in the story again and again. Imagine this happening for just about any movie or any movie theater you go to with no fixes happening. You wouldn't stop going to the movies, right? For the deaf community, that inaccessibility has been our reality. We have been burned so many times that we simply stay home. Open captions is the combination that brings us back to the movies. With open captions, we are able to have fully accessible experiences, and we can enjoy the movies just like hearing moviegoers do. When I go to the movies, it is almost always to the open caption screenings that are available. I have never had a problem with open captions because they are part of the movie. Closed captioning devices are separate from the movies. which means the devices and the system are treated as an afterthought and degrade over time. It is with the greatest reluctance that I ever go to a non-open caption screening. However, open caption screenings are so scattershot in today's voluntary approach that if I miss an open caption screening, I would rather just stay home rather than risk being burned again by another bad experience with a closed caption face. The goal of this legislation is to have a portion of movie screenings in Washington, D.C. be shown with open captions. The movie theater's voluntary approach continues to be insufficient over the years. Many open caption times tend to be during weekday afternoons, even though deaf moviegoers want to go to the movies at the same time as hearing moviegoers on weeknights and on weekends. Open caption options for all titles have been inconsistent too. A movie title may have an open caption screening on one weekend, but not the next weekend. Open captions are the combination at the movies that we need. Consistently available open caption movie screenings across all titles and at reasonable times is the foundation we need to have these accessible experiences. Hawaii pioneered this initiative years ago, and just last year, New York City Council wholeheartedly endorsed such a law. Washington, D.C. boasts one of the most significant deaf and hard of hearing populations in the nation, with more residing in neighboring Maryland and Virginia. By enacting this law in D.C., we will be championing accessibility and ensuring an inclusive environment where everyone can thrive. Thank you, council members, for dedicating your time and attention. We simply seek to enjoy movies just like everyone else. Please cast a vote for this legislation and let's make our movie experiences better for all. Thank you.
Thank you very much for your testimony. Next, we'll have Tawny Holmes Leibach, Executive Director, Conference of Educational Administrators of Schools and Programs for the Deaf.
Hello, Chairperson Nadu and other honorary members of the Council on Committee on Public Works and Operations. My name is Tawny Holmes Hilbach. I work as the Executive Director for Conference of Educational Chair of School and Programs for the Deaf. I'm the oldest, this is the oldest organization for educational direction for the US. We've been over 65 schools and programs for the deaf, including Kendall Elementary School and Model Secondary School for the Deaf here in Washington, D.C. Teachers and students who are members at our schools and other deaf programs here in DC areas want the opportunity to have equality to enjoy movies at the theater. Also, you know that there's many nowadays contemporary lists that can find different movies. There's always wanting to learn something and to discuss, for example, Marvel movies for the Eternals with a famous actress of Lauren Ridloff. She is deaf actress who formerly taught preschool to preschool age children at Lexington School in New York City. That movie had several lessons, which I will describe. One is keep growing, even with change. If you don't grow, then you'll find yourself at the bottom of the chain. The second idea is to search understanding. And the third is no one can take our rights to choose. These lessons are wonderful and they were really enjoyable and beneficial for deaf students to discuss with their teachers in the classroom, but that's only if the teachers and students could have accessibility to go to the movie, to see and watch. With the constant breakdown of devices and with the free movie passes as a Band-Aid, it's consistently for the last 20 years not been the answer. We've starting to give up and lose interest in going to the movie theater, and having that opportunity to bring that educational information to the classroom for discussion. We can't. So that is impacted the economy. So less deaf people going to the movie theater without that accessibility. In the next session, I would encourage the committee members to continue their growth in the deaf community in the city and ensure that the teachers and students have every opportunity to bring their thoughts to the movies and to watch and enjoy with their family, their friends, and to grow as learners and to get the results that will require the council to really seek to understand what it means to go to the movie theater with family and friends and neighbors who can hear, and then we have no way to know. They can come in and enjoy, but if the captioning devices aren't available or they're broken, we feel like second-class citizens. So by that constant occurrence and searching, for the different movie times or begging the theater to provide an open caption movie and texting 20 friends to see who wants to join the group to help convince the theater, that is really just depressing and demoralizing and not equitable. And I encourage the council to go ahead and pass this bill and encourage have the right to choose the movie more often and to be enjoyable, that we can enjoy all that DC offers, that we can be more deaf friendly in the city. Thank you so much.
Thank you so much for your testimony. Next is J. Eugenio Ravello, Vice President, District of Columbia Association of the Deaf.
Okay, hello. My name is Eugenio. I wanted to make sure that I wanted to see everything. I just uploaded my statement. So anyway, I have several points about the open caption. Based on DC's Agency of the Deaf, I've questioned others. One, what is important is the equity inclusion in DC. It's a model city to look in that people look up to in the US. And then also the theater seats aren't only limited for people that could hear, but others that can't hear or can't see. The other thing is the cultural inclusion, meaning that the movie will be reflecting our culture, our society. And then also what's important is to look through the culture and the values throughout. That creative contract, they take out that in the community. And I feel like it's taken out of our culture. It's not included. The next thing is the economy consideration for that economy, that standard. DHH community, like any other community, has funding to go to the movie theater because we can have access to pay. We want the equality to go in and watch the movie. And then what is the benefit for the wider audience? It's not just for the deaf, because many hearing may have hard times to hear, or the actors' accents are hard to understand. So the sound, if they miss it, oh, I can get that. Maybe with the audio is not good quality. If it's not clear, there's no, the open captioning will help them to benefit the understanding. And also technology, it's very advanced. You can set up challenges, but it will be improved over time. If you pass the bill, then we can improve how that will change our lives. And then encouraging, I know our situation, that DC can be the first precedent, set the precedent. Why? Because USA has not set a full city for that open captioning. This would be nice that DC could set this precedent, because many countries, they're partially, not all, like Europe, Canada, Australia, India, Japan, they're not fully integrated in that. They can look at our model city for the world to do that standard, to set the standard. the legal and ethical responsibility following the ADA laws. And that makes sense if you understand that. But what the cons are, some we've mentioned. I'm deafblind myself. I struggle with the devices. The captioning is very small. It would be nice, like in the past experience, I went to New York City theater. It was beautiful. The theater people, not the movie theater, but the actual theater, they had at the bottom, the captioning, the different colored coded captionings. I could watch it all, and everyone could watch, because the voices, they may not be clear. Sometimes you don't catch the message. So with the captioning, it's easy and it's a smooth transition to understand who's talking. And it's the same benefit for the movie theater. I've gone to Europe and I've seen many different movie theaters with the open captioning with my family and friends. I'm from Venezuela in South America for 30 years, and I've always gone to open caption movies my whole life. So that is a wonderful benefit, and it's a good benefit than having to just sit and watch TV at home. We want to be able to go back. We don't want to be stuck in the 1950s, but we want to go back and watch the theater. And I just hope that this will help you with your decision to consider what the benefits are for you, not just for the deaf, but for you as the hearing audience to go watch the open caption movies, which is easy to catch all the information all throughout with different cultures. So that I hope DC, the statehood, the flag would be the first to set up this open caption in the movie theater. And so the whole world can see and have an impact on the world. Thank you for listening.
Thank you so much for your testimony. Okay, so I have a few questions for this panel. And they're for anybody who wants to answer. Will that work logistically? Yes, and I'll just ask anybody who would like to be answering questions, if we could just have everybody turn their video on, then we can spotlight you. And yeah, we just want to make sure that the stream is accessible to everybody who wants to participate. Okay, great. Oh, I see. Okay. What about Brienne? Okay. Okay. So yeah, Brienne, if you want to turn your camera on, you can do that too. All right. So maybe should I call people by name to answer the question just logistically so our interpreter knows who to go to? Okay, I'll do that. Okay. So we'll go in the order that you spoke. Great, there's Brienne. All right. So and how about if you wish to answer the question, pop your hand up when I call your name, and if you don't, then I'll go to the next person. Okay, so the first question, how do you feel about the change in open caption screenings offered now as compared to when a version of this bill was first introduced? Another way of asking that would be, have you seen any change in what's being offered since the original version of the bill was introduced? And I'll start with Brienne Berger, if you'd like to answer the question.
Yeah, I get the pleasure to go first. Okay, thank you. That's a good question. So yes, so from the very beginning, it was sporadic. It was hit or miss. And then also there was a lot of heavy, struggle from the community to kind of tell the theater, please have the turn on the captioning. We want to have advanced notice, details. But to right now, I would say the advocacy is still continuing communication relationship between the community and the movie theater is improving, that they are more willing to regularly provide, but it still has to be kind of accommodated with the schedule, Many theaters are still preferring to show the movie, at odd times of the day when people are at work or the children are in school. So it does not accommodate to what I can't bring my kids to the movie theater. So it still needs to be, thought about. We have busy lives and we're busy, and they need to try to put the theater, shows in the evenings or the weekends where we can also attend, equally as the hearing, customers. So that's a consideration that needs to be put in the bill. And that's why we need, all the details. But I have a feeling that Eric and Tawny and the others have additional, items they want to add. So I'm going to, end it right here.
Thank you. Eric, did you want to add anything?
Are we all taking turns?
Yes,
That what we're doing?
we'll take turns. Yeah.
I'll add something quickly. I'll speak also. So I think there have been more open caption times added over time, but the challenge is a lot of the open caption times are still, on weekday afternoons. And so, like I mentioned in my testimony, I am constantly chasing down to find an available open caption movie time. And like I said, it's not consistent week in and week out because, let's say, with Barbie and Oppenheimer, these were big movies, and a lot of tickets got sold out opening weekend. And there were open caption times, they got sold out. And second weekend, third weekend, there are going to be less and less open caption times, and then there are no more, even though both movies continue to be popular. Because I think the thinking is to open caption movies on opening weekend, and maybe one more weekend, and then that's it. But we would like to be able to go to a movie if it's still in theaters at any time and have open captions to go to. So,
Thank you, Tawny.
I can turn over to Tawny. I know she wanted to say something.
Yes. I would like to add real briefly, you have to think about it. We're not asking for 100% of the movies to show open caption, which would be fully equitable. I'm not asking for that. We're asking for a reasonable percent, to build up that capacity. I think it's very reasonable, and it's, a kind thing to do.
Thank you.
Yes, and I would like to add, remember, I just recently mentioned about benefit for the hearing audience. So it could be 100%. I don't know, hearing could have issues with, their hearing and have an opportunity to be in the movie theater, but understand it's a wonderful benefit. Like, for example, if you, the committee members, if I give you homework and you go to the movie theater and you read a book, if you don't watch the screen, what's it's saying, I would prefer to have the open captioning up on the screen because I'm only limited where my eyesight is. That's all, in that spectrum of my eyesight. So there's a much benefit for the hearing people also. That's it.
Thank you so much. Does anyone have an opinion on what you think is an appropriate number of open captioned screenings? The bill has 12%. Is that the right place to be, or would you have set it at a different number?
I have an answer.
Go ahead.
Okay, so Eric and I started this from a long time ago, and 9 years ago, possibly. I've lost time, but when we first approached the council and suggested the idea of mandated show times established, we did work on a formula and tried to see what would work for the movie theaters. That's reasonable amount of their movie screens plus showings on each screen. So the days plus, what could be fit for the deaf community to be able to attend at least, once, a day or for a showing, or we did come up to an agreement of 12%. So far it's they've maintained the 12% because that was, that was the starting consideration with the council, that they studied the movie theater show times, how often throughout the day, depending on how many screens that each movie theater had. So if that one screen is a different formula compared to other, movie theater that has 5 screens, then I think we have to figure out an additional, maybe we've missed some. So maybe, I don't know if 12% is a good number.
Yeah, I can add on to that. I think in addition to 12% is to make sure that open captions are at reasonable times. So it's not like 12% and they will all wind up on Tuesday afternoon, for example. So we will guarantee that there will be something happening on the weekend. So I think that is a fair balance because, society had not been used to captions. I like to tell people that if everyone just grew up with captions, this would not be a big deal. But we're basically in the middle of a transition where there are more headlines nowadays where people are enjoying using captions and subtitles, especially with streaming services. So I think 12% is completely reasonable, and I think that still leaves more non-open caption screenings for everyone else. I think that it will be a fair number of open caption screenings for all the movies that will be showing.
Thank you so much. Are there other accessibility measures like sensory friendly or family screenings we should consider? I see nodding. Okay. Yep. Okay.
Yes. Yes, I wanted to say that I suggest how sensory I would, prefer like the color captioning, like orange, because orange is more friendly, not the white, it's so drastic, not the red, but orange seems to be a good color. And I prefer that. And also, I wanted to add that Eugenio, so I think I should go first because he's a deaf and blind person. He has several, issues that he could make a great point about the visibility issues and challenges that some, customers may have, not just deaf or deaf blind, but also the hearing people, they may experience that same issue. So yes, that is true. There are some sensory concerns that we should consider in the bill, like also like we need to say why that needs to be put in the bill, because it's just some people can't just balance 2 things at the same time. One device watching and then watching the screen. Some people really struggle physically and they need to have it all included in one screen together. That's all included. And also I'd like to add, this is Tawny here. And I also would like to add, looking at the international scene, they've already set up, open captioning. They call it subtitles in foreign films. It's very popular here in the DC area, in Silver Spring. It's very popular. They already have, that in action. So it's not something that's new. I believe that's where the US movie, theaters are behind other movie theaters in other countries, because they typically give open captioning on their movies. Like in Asia, they may have movies with English speakers with the, Asian captionings. They're already used to it. That's where we can make ourselves more local or global at that time, because many international people that live here in town. So that's where we could have that perspective. And then IMAX movies are very popular for the deaf, audience to have full access with the sounds and the 3D movies. We want to be included in that. I want to make sure that we're included in the animated movies for families with deaf children and hearing adults with deaf children that have the opportunity to enjoy movies with their families, like animated movies at appropriate times in the afternoons or in the evenings or on the weekends, not just, depending on the age of the children. So I think that would be very important consideration. Yes, I agree.
Thank you very much. How do you feel about the open caption requirements that are now in effect in New York City? New York still requires showings at diverse times and during a defined set of peak hours, but caps the requirement of open caption showings at 4 per week.
So you're saying 4 times a week? That's good.
That's good. Okay.
Yes, yes. And this is, oh, Eric, did you want to?
I think that the percentage, sorry, I'll stop signing. The percentage is based on the number of screenings that the theater will show in general. So the more popular the movie is, the more open caption times there will be. So I think it's fair to scale it up accordingly. So I think that, capping it doesn't make much sense to me because, if a movie is very popular, then, you're going to have more auditorium filled. Sometimes I try open caption screening, but it's already pretty filled up because people are excited for it and don't mind the open captions. So I think, if there are many non-open caption options, we can index the number of open caption screenings with that.
Go ahead.
Yeah, I wanted to say real quick, understand that 4 times a week, that, like, if you think about how many movies in a week, I feel like it's really a low percentage. That's fine. I understand that. But the impact economy, you could get more money. If the theaters think about it, the more open captions theaters, they'll have more opportunity to make more money, and there'll be more customers coming in DC to come to that movie. Even tourists fly in if they're bored. I don't know what to do today. They go to the movie. Then that's a very, because we're a very international town. It increases our tourism to come to the movies for the foreigners also. Remember that you have to remember all of that. And this is Tawny. I would also like to add that the number of movies a week in Hawaii, they require 2 times a week, but that is not equitable formula for a small area. But for a large movie theater, that community, we're just trying to figure out the best formula that would make sure that it would be accommodating for the amount of movies that are shown per week. So we have to figure out a way to have X number of movies shown a week that are open captioning. That might be easiest to, not instead of just having a blanket formula, but we have to figure out if the movie is popular that week, because it all fluctuates week by week.
Thank you very much. How important is it that open caption requirements be cited under the DC Human Rights Act?
Yes, because hearing people benefit also. And also, so yes, I think that's an interesting question. I did go back and review the Human Rights Act. I think I've only read it once, and I don't remember it at the time, but I think that it would be a great place to add, a reference to that bill to connect the two. So it's a full, to have full support and accessibility for that universal design for both benefits, hearing, population, the deaf. It doesn't matter. It should all be in because it's a human right. Yes. So I am, I would still have to review it, but I would say yes. And then I wanted to add quickly, I've already experienced in Catalonian region in Mexico, they have their different language. They have their own, what's it called? English. It's not their law, but some type of state law saying that they would add language as an important, where it's equality. So it's thorough. Accessibility, that concept is not only for a class of people with a disability, but it's designed universally that could be applied. So that is then added like 4 different languages, a formal language that the movie theater has the option to add 4 different languages for the whole community, having diversity for human right, and that is proportionate to here. It would be nice if that could be a, to have the US to be first, to have that possibility. I encourage that, to be noted, and we can set a precedent about that. That could be very successful. I would agree to that, to put in the Human Rights Act.
Thank you very much. How do we actually enforce these requirements? It should be easy enough to require the theaters to publish which showings they have open captions and compare that to what's in place. I'm sorry, what's required? Is it enough to have a portal to report that, or a place to report that?
This is Tawny. Yes, I would say that there's a few independent organizations that do publish on the list of movies that are available that week in DC with open captions, both closed and open caption. So possibly that's where that email could be helped tracking which movie theater, if they can put it on, a central website where deaf people can check to have an updated analytics of what's going to be put, set. Is it 12%? Is it automated? It's something that can be set up that, that can quantify what we're looking for, and that some type of work that, I don't agree. I would agree to work with that policy now. If I want to see all the listings of different movies, I would have to check my email, but then from then on, I would have to pay for that accessibility with that organization. But I want to be able to look in one specific place to know, quickly what's available for that week and that planning. Maybe, if the schools want to do a field trip, it'd be easier for them to watch and see what's available. But, that would be good for, maybe the other panelists could help. And I believe it's already included. The language itself, the portal is not, we don't use that word, but in the bill, it does refer to an outreach activity. So that possibly could be where we could expand and add the portal under the outreach activity.
I would like to add also that accountability is absolutely needed. Accountability is why the closed caption devices have not been maintained and taken care of, and we've never gotten any recourse about that. So I think that there's a lot of messiness involved with the devices because theaters do not have the technicians involved to do that, where open captions are already part of the movie. So it's a lot matter of turning it on. There could be human error once in a while if someone forgets to turn it on, but that's easily fixed. I've gone to an open caption movie. It's been a while now, but sometimes they start over the movie with turning on the open captions. So that's a lot easier than dealing with a device, having to go get services and coming back. But I definitely think there should be a portal of some sort where a deaf moviegoer can say, I expected open captions, this was not happening. The theater needs to be held accountable in some way. I don't know how exactly, but there definitely should be a portal.
Rona, do you need to switch?
Yes, if you don't mind, yes. Thank you.
Two final questions, and then I'm gonna give Councilmember Allen, who has joined us, an opportunity to do his opening statement. Oh, it's not going. The interpretation is not going. He's not in the Zoom. Oh, well, they were telling me that it's not.
This is Rona. I can see the interpreter. I don't know if they can see the interpreter. He's saying it's not working. I can see him on the screen.
Looks like. Just hold on a moment.
They're asking if you can spotlight me. I'm really small.
Thank you for your patience. Just two final questions for this panel, and then we'll turn to Councilmember Allen, who has joined us a little while ago for an opening statement. What do you think we should do about single screen theaters?
For signing? That language is already included in the bill, so we already have a format that we agreed on for collaborating that amongst the councilmen and the council to kind of based on that. So what the numbers of what it shows, the theaters, the screen, and mostly on the screen, we already added that in the bill.
For theaters with only one screen? Okay.
Yes, it's already in the bill. Yeah.
And then what about films that don't have open captions provided? How do you normally deal with that?
Don't go. We don't go. We don't go to the movies.
So I think my understanding of captioned, open captions are available because the studios provide it. Sometimes there can be very small movies that, you know, won't have captions added in, that they just can't turn anything on, either with the closed caption devices or the open caption devices. So I think, you know, the companies need to be petitioned, but it's like, if the captions are not there, it's not that theaters can't be responsible for making the captions. So I think it's kind of beyond the purview of DC, essentially. I mean, I don't want to discourage small distributors to not be able to release their movies, and I want open captions for them, but that feels like it's more of a national scope thing that we need to address, like for distributors to get funding to make sure that, you know, their indie productions are captioned.
Thank you.
Yeah, that's it for me.
Virginia.
I'd like to make a statement. So you mentioned that, Eric, DC want to do like a building, but they benefit nationally, yes. But it's a model later. It's going to go rampant. It's going to spread very fast. And also, if there's no open captions available, I feel like my rights have been, and my human rights have been violated and taken out. I'm not really give up. I figure it out and I try to fight through it and I try to make it work. And once this bill passes, oh my gosh, you know, the open captions. And if it doesn't, then again, my rights have been violated and taken out. And also want like to mention too, Americans with Disability Act, it's a federal law. So technically all movie theaters should have open captions. It's a law, it's required, it's federal, and it's there. So this bill is very important. It's a huge step to avoid liability under the ADA that's already stated that movie theater and companies should have, you know, accessibility. It's legal. It's a private business, accessibility, equality to all. And Congress should support it and lead it and to reduce their liability because it's already in place. But I haven't seen a lot of availability for open movie theaters. It's very frustrating, but there's legal actions that have been sued because of this right. And same as goes to DC. So I'm looking forward to open accessibility across the board. For the economy, it's going to be amazing. For child of deaf adults, for kids who are deaf, for hearing parents, it's benefits to all. So just reason that, it's all families. And if you have one deaf child who can't see that movie, that the whole family's not going to go now. So myself, I feel like the movie, I have to wait until it releases on Netflix. That's me I pay for the streaming service. If I can't go into movie theater, then I'll go to Netflix, and I pay all for streaming services when it gets released. So they just lost a valid customer, and that it definitely impacts the economy. And we have a question. I just want to not direct to this question, but more on the lines of the records, the data during this hearing. Eric and I will follow up after the hearing to discuss about this interpreting services. There's no discrimination. There's no, they're both doing their best they can, and they're following accurate, statements while we're trying to say our dialogue, but there's a lot of mistakes. And they're human, and I can't read their minds, and they can't read ours. So speaking what we're asking to make sure that they read the testimony that we have submitted. Make sure that they read and that we have said and is appropriate and it's already documented, and not depending on the interpreting and how they're interpreting and a lot of the mistakes that they're doing. So for this dialogue, this discussion, have an opportunity to write the answer. We didn't have that. So some questions that you felt maybe the interpreter misunderstood what we said, I encourage the council to please follow up and emailing the questions, question by question, and we have the opportunity to type out word for word of what we are saying and answering your question, if you could do that. The point is, and again, I'm not criticizing the interpreters. They're doing their best they can without, a lot of preparation. But I understand that, sometimes the interpreters are not very accurate at what we're trying to share with you and say. Thank you so much. Thank you. Thank you. Good.
Thank you. No problem. We'll be glad to send the questions to you.
Awesome. Thank you.
Thank you to this panel. Okay, so I'm going to actually call, I'm going to let Councilmember Allen speak while we're promoting everybody, but I'm going to do the roll call first. So,
should I turn off my camera?
yes,
should we
you
all-
all are finished. Thank you. We're good. Okay, so I'm going to take together, based on the fact that not everybody has arrived to the Zoom, I'm going to take together panels 2, 3, and 4. I will read every person's name that has signed up. But obviously, if you're not in the Zoom, we can't promote you. And if you don't get an invitation to be promoted, it may be that you have signed up on the Zoom with the wrong name. Raise your hand using the raise hand function. We'll figure it out. We'll message with you. But this will be panels 2, 3, and 4 combined. So that includes Andrea Pacifiumi, Dale Brown, Mallory Marchant, Leslie Kang, Gabriela Santos, Alim Shandini, Keith Delk, Danielle Fisher, Jarvis Grindstaff, Ashod Daradanyan, Noah Spinosi, Jordan Nassar, Sharon Nordloff, and Emily Rodriguez Romero. While everybody is being promoted, I will turn to my colleague, Councilmember Charles Allen, to make an opening statement.
Thank you very much, Chair Nadeau, for holding today's hearing. I will also apologize in advance that I am chairing my own hearing in just a few minutes. So I'm going to leave my opening statement here, and then I'm going to have to leave to go chair a hearing in just a moment. But let me also thank everybody who's showed up today to testify. The District of Columbia is home to nearly 10,000 deaf and hard of hearing residents, and it is nationally recognized for its efforts to ensure that services meet the needs of these residents. Still, though, our deaf community, many of whom use American Sign Language as their main language, must navigate significant obstacles to ensure they can access certain services and programming that other hearing residents readily enjoy and at ease. One of these barriers is a staple. It's an American pastime. It's going to the movies. Going to the movies is more than just a leisure activity. It's often the backdrop for countless memories and shared experiences. It's where we go to watch the latest summer blockbuster, a scary movie at Halloween, or a tearjerker with friends and family. The deaf community, however, faces challenges when it comes to enjoying this pastime and this cherished experience. Beginning in 1997 and continuing today, movie theaters are required under the Americans with Disabilities Act to accommodate those who are deaf or hard of hearing, but they can decide if and when they use open captions during screenings. This is usually in the form of closed captioning devices like captioning glasses and displays that fit into cup holders or onto chair armrests. But deaf moviegoers encounter a range of problems with these devices, everything from battery failure to just a lack of connectivity. And when the council held a hearing on this previous version of this legislation several years ago, those challenges were made clear in a way that most hearing residents had just simply never realized. But even before deaf moviegoers encounter challenges with these devices, they often face the headache of trying to obtain one from the ticket counter or the concession staff at theaters, who often cannot locate these devices or get them to function properly. And by the time things have finally sorted out, the movie's already started, and that deaf moviegoer feels their moviegoing experience is already ruined. And that's why I introduced legislation this year again, as I have every council period since 2018, to address the concerns of the deaf community about open captioning, which should display the captions on the screen for everyone, including dialogue, sound effects, and music. But since introducing this bill, I have also been impressed by the breadth of support for the legislation. I've been contacted by organizations representing seniors who believe it will make a difference and it will bring them back to the movie theaters. I've been contacted by veteran groups who have too many members struggling with hearing loss from combat experience and are unable to enjoy movies today. I've been contacted by parents of young children who see the benefits as a hearing family to have open captions that help their children learn to read and enjoy that latest family movie. Our bill would create several requirements for movie theaters across the district, allowing for more deaf moviegoers to enjoy the experience in the same way as hearing moviegoers. But it's clear from what we've heard, this will benefit a large number of residents. Now, for anyone who still doubts that open captions are somehow going to stop people from watching a movie or a show, just last week, Netflix dropped its latest season of Lupin. It is the 5th most popular series in America at the moment. Now, maybe you're going to argue to me that millions and millions of Americans just became fluent in French overnight. But the reality is a whole lot of people are clearly okay watching and enjoying a show using open captions. This legislation will require a certain percentage of screens to display open captions based on the number of screens in that theater. It would require better notice and promotion of open captioning offerings at theaters across the district. It would direct the mayor to launch a public awareness campaign about open captions in movie theaters. And importantly, it would ensure that open captions are available during both peak and non-peak operating hours, so deaf moviegoers can enjoy the theater in the same way as everybody else. I also want to take a moment to acknowledge the first anniversary of the Office of Deaf, Blind, and Hard of Hearing, created out of legislation that I introduced in 2018 and again in 2019, based on extensive discussions with the deaf and hard of hearing community who educated me on the challenges they face every day to access public services. This office has been and will continue to be an integral partner across the district in helping to achieve the aims of the deaf and hard of hearing community to have greater accessibility in all services and programming across the district, as well as helping ensure that our laws and policies, like the legislation before us today, is implemented and complied with. I also want to express my deep thanks to the members and leaders of the deaf and hard of hearing community that first brought this issue to my attention and have continued to fight with us to make this needed change. And I also want to thank members of the movie theater industry that met with me recently to outline constructive recommendations they have to the introduced bill to best be able to implement many of the changes that it seeks, and to ensure the system has accountability that we need to protect our residents and visitors. That collaborative approach is welcome as we work to both expand open captions for all of our residents and, of course, support our businesses in the city. So thank you again, Chair Nadeau, for holding this hearing, this legislation today. Thanks to all of our public witnesses. I'm sorry that I've got to go chair a different hearing, and so I can't stay for this next round of public witnesses, but I look forward to working with you to finally get this legislation in front of the full council for a vote. So thank you.
Thank you, Chairman Allen, Councilmember Allen, for your leadership on this, and good luck with your hearing today. Okay, so I believe we now have a panel that includes Andrea.
Hi, can you hear me?
Yes, Jordan, we can hear you. And you're going to
Wait,
be,
well, do I get my testimony now? Yeah.
you're not yet, you're number 5 on this panel. Okay, great. So actually first we'll hear from Andrea Pacifiumi.
Hi, are you ready for me to go?
Yes, please.
Hi, good afternoon, council members, and to everyone here. My name is Andrea Pacifium, and I speak in support of the Open Caption Requirement Act of 2023. I have worked 20 years as a professional film programmer. I spent many years with the American Film Institute, both in Los Angeles and DC. And I currently program feature films for a variety of prominent film festivals around the US, including Sundance, Tribeca, and the Seattle Deaf Film Festival. I also happen to have been born with single-sided deafness, and I'm proudly part of the deaf and hard of hearing community. Open captioning is by far the best way to give deaf and hard of hearing people access to films and movie theaters. Portable captioning devices that have been previously made available in theaters are not effective. They often don't work properly, as you've heard. Power sources aren't charged. They are often poorly maintained. Staff is often not trained properly on how to use them, if they even know where the devices are located. And if you are lucky enough to get a working device in a timely manner, the movie-going experience is dramatically lessened by the awkward configuration of these devices. We deserve an equal movie-going experience. Deaf and hard of hearing people go to the movies like everyone else, but open caption screenings are very limited in number and often scheduled at odd times. Why is this? Do people think deaf and hard of hearing people don't go to the movies? We love going to the movies, but we also have jobs and families and meetings and activities just like everyone else. When there are only a couple of obscure screening times offered for open caption movies, it severely limits our choices. This marginalizes the deaf and hard of hearing community and sends the message that we aren't important, that we don't matter, but we do matter. Maybe some people think that general audiences at premium screening times would be annoyed to watch open captions on a film. But I go to open caption screenings all the time around the DC area, and half the time it's clear that the hearing people in the audience don't even realize they've wandered into an open caption screening. But I have never once seen a hearing audience member complain or walk out. If anything, everyone seems to actually appreciate being able to fully understand the dialogue, and many end up realizing how much they were missing. If anyone here today at this meeting hasn't actually attended an open caption screening in a theater, I strongly encourage you to do that. Go and see for yourself what this enhanced experience is like. Watch the audience around you, observe how everyone appreciates and enjoys the experience. See how much extra information you personally pick up when watching an open caption film in the theater. And if you do decide to go to an open caption screening, you will also see for yourself just how limited your choices are. Let's do better for our deaf and hard of hearing community. Deaf and hard of hearing people are viable consumers We go to the movies and we matter. So thank you for listening.
Thank you very much for your testimony. We'll now hear from Dale Brown. Sorry, we will go to Alim Shandini. Just a moment. There we go.
Hello. Okay, he can't see the interpreter. One moment. Hello, my name is Aline. Okay, he can see me now. All right. Hello, my name is Aline Chandji. I work in international connections at Gallaudet, and most of you have already named the reasons why we need to support for open captioned movies. There's a big, I support that myself, go to the movies. I love the movies. I just recently wanted to add that the international point of view from where I did work as an expat in India for 5 years, they are behind, but at the same time, we have hit, advances in the captioning in the Indian theaters in different languages, and how we provide English captions that would help, all the children, not just the deaf, but the hearing children, and that would improve their reading, a literary rate for their reading skills and their writing. So one way to improve, that is through the movie theater with the open captioning. That's what I really recommend for the deaf people in India, so they will know, that English is their first or second language, where they can, visit and do the best they can with reading and their cognitive skills when it comes to, they're able to learn and enjoy, because while in school, they may be, missing, or there's a lack of communication, or there's no teacher, there's no accessibility to an interpreter. So what's the other option is movies or TV or the news, that we have the option, it's proportional. If we did provide that here in America, that would be a wake-up call for many different cultures in the area, so that they can be able to access that. And I do have other points, but that are in my testimonial that you can read those other points.
Thank you very much. And okay, we had Dale, but we lost Dale again. Okay, so we'll go to Keith Delk. Oh, where's Keith? Oh, there you are. Great. One minute, Keith. Rona, can you not see him?
I'm trying to pin him.
Oh, okay. One moment, Keith. I'm sorry.
Okay. Yeah, I just wanted to comment that many people are sharing their experiences are very valid. I feel connected with all of that. For example, Andrea, she said that people in the movie theater are, wondering, do people leave the movie theater once they come in if there's an open caption on the screen? Well, no, I've never heard of that situation, but I do hear stories of people leaving the theater because of bad devices that's a different perspective. So I think about, there's no hurt in having open captions in the theater. I'm Keith, and I've lived in Rochester, New York, and Washington, D.C., and they're both big deaf communities. And I support the open captioning for the last 10 years. And I've always had in that time collected many vouchers, movie tickets. Why? Because the assistive devices have failed. So that is a bad experience that has caused me to stay home and then become my movie theater, experiences like Tawny, deciding that there's many visitors that don't want to go out. They don't feel comfortable in the theater, but they feel comfortable with Netflix and all this streaming platforms because they have the captions. I did have an opportunity with NAD to sue. So NAD had already developed their accessibility to captionings, and I would visit movie theaters and explained, all these different things that are championed. And I just imagine that the movie theaters need to follow that as same as the streaming platforms, because they have taken over, and they want to lose to the movie theaters. So that's the new generation that are setting up the new standard for accessibility and inclusion. So many movie theaters that, all the digital platforms online are captioned. All the movies are captioned. The content, 60 to 70% of the content is captioned. So why not at the movie theater? I'm just wondering, RIT, Rochester School for Institute for the Deaf, they had film programs there. They would show films that many students were required, not many, but all students required the open captioning of their top films in for the senior year. So they knew to include that for accessibility for the deaf and hard of hearing students on campus. So why are the younger generation requiring that? They need to set that up in the movie theaters also. That just makes me wonder, why not? So with that short story, I would like for some of you guys to go ahead and take the opportunity to experience, like we do as deaf consumers with those assistive devices in the movie theater. Go ahead and use that experience, your paper or laptop or tablet, and look at the paper of the 1 feet in front of your face. And then you try to look at your tablet at the movie screen or what's in front of you. And you look at the paper, look at the screen, and try that 5 times, practice that 5 times. And that will then give you the idea of how it is at the movie theater by looking at the device and the screen, like 90 seconds, looking back and forth. It's just exhausting. It's really exhausting. And then also we would have to use, dirty, noisy devices, bad technology, technical issues that are not equitable to all of the deaf, consumers, the hard of hearing consumers. And that is also a stain for us, because America is a complete, idea for inclusion and equity, but that is not part of the ADA. Biden had already added that accessibility as a foundation for IDEA. So that is a strong part of America. And that now in the movie theaters, they want to ignore that cherished meaning that, we as American, that's the foundation. We're becoming weak. And especially for the theaters, that might be like 100 years since 1910, 1920, the movie theaters have been established. And it goes along with the concept of America. And now, is that reflecting what we are as Americans? So the whole point is the movie theater is not just about enjoyment, but it's about connection, the human experience. We fight for accessibility and equity in the theater. And it's very important to understand that not everyone needs accessibility in the universe, but it's more about having, there's many parts that are not equitable, but we need to have that equitable experience. There's a lot of resources, the open door opportunity for those who have been, marginalized. Now it's our time to get the opportunity in the movie theater.
Thank you.
Thank you.
Next, we'll have Jordan Nasser.
Oh. Hi, my name is Jordan Nasser, and I'm currently an ANC commissioner for ANC 2A, but I speak here on my own behalf as a person who is deaf and part of a local deaf community, both oral and sign. I came here this morning to show my support for the Open Movie Captioning Requirement Act of 2023. I have heard of arguments against the open captioning bill. On the argument that there will not be enough people showing up, it is often because many open captioning movies are not shown within when they're first released. Movies released much later than the release date simply often have a empty seat. Second, many theaters that are already many theaters currently are facing many issues of empty seats due to COVID, oversupply of screens, and the trend to watch movies at home. And they can so currently the theaters can more than accommodate a marginalized population by providing a screen that is accessible for all. Third, it is already a proven point that captioning are often utilized on streaming services at high percentages and is not a deterrent for going out to watch movies. Loss of ticket sales to caption films do not outweigh loss of ticket sales due to films not being made accessible. Captioning has gone mainstream in the homes of general public since the adoption of the American with Disability Act of 1990. Let's fix the facts. In areas where similar legislation have already passed, people are still going to the movies, and there has not been an increase in ticket prices as a result of a passage. For many of us in the deaf and hard of hearing community, this bill also produces mixed feelings. Why? Because it is a trivial bill. Since not all the movies will be captioned and it will not apply to every movie theater in the district. But it is also a monumental bill, as it is a step in the right direction and signals that the deaf and the hard of hearing community is being heard. It's monumental in a district whose public school system website touts American Sign Language as one of the worst languages being taught in the schools. But when calling every high school in the district, not a single high school is offering it. It is monumental in the district whose public schools say they want to promote equity, but deaf and hard of hearing teachers in the district are relying on interpreters assigned to deaf and hard of hearing students for their own interpreting needs instead of being given their own interpreters, therefore limiting those teachers' employment opportunities to classes that only have deaf and hard of hearing students. It is monumental in a district that over 100 years have touted having Gallaudet University as one of its local universities, and have redirected questions pertaining to deafness to the university, and only too recently have established the mayor's office of deaf, blind, and hard of hearing. It is monumental in the district where many public events are only recently being interpreted as a standard, thanks to the office of the deaf and the deafblind and the deaf and the hard of hearing. But there are still other public events that are not being interpreted, as it has yet to be set as a standard, and the process of requesting for interpreters by district visitors and residents is still not simplified. It is monumental in the district where any interpreting certifications are not required in the schools for deaf and hard of hearing students to understand educational materials effectively, and where there is no district-wide board of evaluation for interpreters at this time to assess the quality of interpreters within the district, whereas many other states have had some kind of system in place for decades. It is monumental in the district where, with a large deaf and hard of hearing population in this metropolitan area, where movies and TV in public spaces are still often not set up automatically to be captioned. As for this legislation, it's a small step forward, but a large statement, as it will allow for members of our deaf and hard of hearing people the freedom to choose their local movie theaters instead of being confined to 1 or 2 theaters that are currently providing captions at practical times for a decent number of theaters. Confining a population to a single or 1 or 2 theaters is not a good practice for any, and it's a form of apartheid, and it's restricting access of for our district deaf and hard of hearing residents, as I mentioned before. Visible access to language any and everywhere is critical to incidental learning that is often behind understanding societal cultural norms. There's a reason why deaf culture exists, because we have our own language and learning environments that are unique and separate from the hearing community. And a lot of it comes from isolation that we all experience, being language deprived in hearing environments. So yes, as you can see, in our nation's capital, we still have a long way to go to get to where the district should be in guaranteeing the success of members of our community in gaining proper education and employment. None of which can happen without proper recognition of the deficiencies that are currently in place. Regardless, we have continued to make small strides, but as Jennifer Keenan sharpens, climbed the steps of the Supreme Court to demand the Congress to immediately pass the Starter ADA Act with no weakening amendments, we too are still metaphorically climbing the steps as well. And it's with this recognition that every small gain comes with a step taken to equity. I urge the DC Council and the committee to support and pass this bill. Thank you.
Thank you. Sorry. Thank you very much to this panel. Sorry for your testimony. So we now have Dale Brown with us. And Dale, make sure to unmute yourself if you're going to speak for your testimony. Yep.
Okay, thank you very much. Thank you for all you've already done for people with hearing impairments. You helped me with my hearing aids through the hearing, what is it called? The Hearing Aid Assistance Program. And I thought it was important to add my voice, even though I don't at the moment technically represent anybody, because I'm one of the people who is not deaf, and I thank very much for my deaf colleagues for bringing this up, but for whom captions make a huge difference in how I enjoy a film. In other words, for me, I have very mild hearing loss. I use hearing aids, but if there aren't captions, I have to work hard to understand every word. If there are captions, I can relax. Right now, if I watch a movie, I rarely go to movies because they're a little difficult. If this bill passes, and if I can easily find out when caption movies are on, I'm going to come and I'm bringing a lot of friends. And right now, if someone has to beg me to go to a movie, I will go, and I do, and I like many movies. I'm actually a movie lover. I frequently now watch movies on YouTube. I frequently watch movies on Netflix. But if this bill passes, I'll go a lot more. I think this will bring more revenue to DC, possibly. I think that you will find that people from Maryland and Virginia will go. And I think if the movie theaters can use this as a business opportunity, it could bring them profit. They could go to ARP, they could go to many of the nonprofit groups, make sure that the captioned movies are advertised, and they could make a lot of money. I wanted to end with something that a lot of people have talked about, and that is about, a month ago, suddenly I was offered a cup holder. I found out about it, that you could put the captions in the cup holder and see the captions. And I was so excited. Well, it didn't work at all. First of all, it kept falling out of my cup. And second of all, you had to look down in order to see the captions. So I couldn't enjoy the movie. Also, I've also had problems with other accommodations. So basically, I want to encourage you to pass this act. I want to encourage you to keep going. I want to thank my deaf colleagues, and I want to thank you for all that you have done, and my deaf and hard of hearing colleagues. And thank you for all you have done. And to recognize that there are many, many people. I am, even though I'm not technically representing anyone, believe me, among seniors, just among people I know, many people have stopped going to movies simply because, not that they're inaccessible completely, not that they can't go with their grandchildren, but that they have to really work at it when there's no captions. If you can possibly pass this bill, we'll be able to enjoy them. Thank you.
Thank you for your testimony. We'll now hear from Emily Rodriguez Romero.
Okay, so can I go ahead and start?
Yes.
Perfect. Hello. Good afternoon, everybody. My name is Emily Rodriguez Romero. I'm honored to be a witness here in this testimonial trial. The Movie Caption Requirement Act of 2023, valued, very important, recognizing that all the committee and Congress to recognize and show that this is an ongoing struggle with accessibility and inclusion, to know that the movie theater will always find 3 caption devices. First one is the mirror caption, smart glasses, and the caption and stand that's on the soda machine, on the soda thing. So it leaves me really feeling isolated, disconnected, and robbed of my accessibility and my inclusion. And what I wish for is not there. I should be empowered, but it still feels like it failed. They're missing the opportunity for a joy, to get recognition, to enjoy it, not only to be beneficial for the deaf and hard of hearing community, but also the DC residents to learn what disability is. And also other benefits, you know, being very clear, advocacy of languages, for multiple languages in the audience. In my background, I'm Latino. My whole family speaks Spanish, and they're helping them too, to help me with my English and helping them with English too. I am deaf and I do rely on captions too. I love movies. And more, please remember that DC is well known as it's the nation's capital. And this act, if it passes, means that other states around the world will look up to DC even more as a nation's capital and a great role model. In addition, here, right here in DC, I'm a DC resident. They have values. We have values. And I hope that everybody in the community and the council and Congress will live up to the state's value of accessibility and inclusion for all of DC residents. So thank you so much.
Thank you very much for your testimony.
All of DC residents. So thank you so much. Thank you.
So for this panel, just a few questions, and anyone who wants to answer is welcome to do so. How have you felt about any changes in open caption screenings offered now as compared to when the bill was first introduced several years ago? Have you seen any improvement over that time? We'll
Keith
go
Keith wants
to Keith and then Dale.
I live in DC, roughly 5 years, close to it. I don't have much knowledge on it, but my personal experience in these almost 5 years, local movie theaters, they're cherished, they're more welcoming, they're inviting us and opening the captions compared with the chain movie theaters. My personal experience, not for everyone, I don't know what's going on out there, but for an example, Gallaudet University has a movie theater right next to it, Angelica Pop. And also Silver Spring, Maryland has a movie theater too. Both of them, and I forgot the name in Silver Springs, but very warming. Silver Spring, Maryland, yeah. So those two are very local movie theaters that are welcoming. Deaf community, hard of hearing, loss of hearing. They're very welcoming and warm, and they're, a compliance with us. They're called the big dogs, quote unquote. So that's where I feel more support them because of that. The one next to Gallaudet, because it's the center of the deaf and hard of hearing community, right in the center. I felt like they bring us and warm us, with open arms welcome. Compared to big movie theaters, they're kind of outside of the heart. They're a little outside, not really caring. More resistance, more related to their movies. It's a great observation that I've taken.
Okay, so Dale and then Emily and then Andrea.
Yeah, I just wanted to say, I haven't noticed a lot of change, but I also wanted to say that as a person who's not super well connected with trying to figure this out, because for me, I just gradually withdrew from movies. I think it's really important that whatever is done with this bill, that you assure that you keep on telling people when those open captions are, and that that's done really clearly and really well.
Andrea.
I've noticed a really great increase in since I've noticed movie theaters increasing the number of open caption screenings, as well as advertising more of the open caption screenings. And that's a key element, is to let people know it's happening. And a shout out to Eric Nordloff, who's in the greater group here, who's done a sensational job of keeping residents informed of the open caption screenings, because it can be very difficult to actually search through and find when the open caption screenings are actually happening. But when I attend open caption screenings, which is often, they're growing. They're always very full. In my experience, I recently saw an open caption screening of Barbie with a huge audience. That was great fun. Hearing and deaf mix, and hearing and deaf come to all of it. It's not just deaf. Hearing love it, hard of hearing. And I went to an open caption screening of Stop Making Sense just about a week ago. Some people think, oh, why would a deaf person want to see the Taylor Swift concert film or Talking Heads? It's a music concert. I absolutely want to see those. And I'm seeing more and more people coming to those and enjoying them. And there's a spirit of community building because of it. So that's what I observe.
Thank you. Emily?
Yes, honestly, I moved from another country, Dominican Republic. So I jumped a year into 2005, where I was impressed with what they provided accessibility wise, until I was a teenage year, started college. I was excited. Oh, you have accessibility. You have devices. Oh, I'm ready to see it. Oh, yeah. Okay. I appreciate that the attempt to provide accessibility, but it's still, I'm struggling with a full enjoyment throughout the movie. That's what I've seen change from before till now.
Jordan?
I've been in DC for only 2 years, but from my observation, when I moved here, I lived near the AMC in Georgetown, so I'm lucky that I have a movie theater that has a lot of open caption showing, and I only go out to see the movies with those showing. But I do have a lot of friends who live near Gallaudet area, and I've noticed that whenever I've asked if they wanted to watch a movie with me, they often prefer to go to Regal. the one in Gallery Place, only because it's closer to Gallery. Even though if you look at the testimony that AMC and Regal gave and posted online, you can see that AMC offered more open caption films than Regal Cinema in Chinatown. So it's apparent to me that a lot of my friends, they would prefer, if they have been given a choice, to go to the local movie theater close to their own homes.
Next question is, the bill has the number of screenings at, or it has the percentage.
Oh, hold on one second. Keith, want to say something?
Oh, you have another thing to add?
Yes, relate to your first question.
Oh, I'm sorry. I thought you went. I apologize.
So do you have any numbers statistic wise to show if adding open captions for viewers for emissions will help the bill pass? I'm curious. Do you have anything, any numbers, any statistics that you can compare? Who leaves, who doesn't, who's failed? You know, caption devices have failed. Any statistics proven? I'm curious. What's changed, you know, from statistic wise from before, and then when the bill, if the bill passes from here and then, if it legit, you know, if they, you know, post, during the pandemic and retaliation. But I'm saying, as statistics shown, if a normal day, open captions, you have statistics that show. I'm very curious in that findings, if you have it.
I don't. That may be something our next panel may be able to speak to, though. Okay, so next question is, what do you think is an appropriate number of open captioned screenings? Is 12% the right amount? That's what's in the bill? Or would it be better to have a set number like New York has, where they have a cap of 4? Oh, yeah, go ahead, Keith.
So ADA, I already know, they already have unburdened small business to provide accommodation services in ADA. I can't remember the exact employment number that's less than, it doesn't have to provide services under the funded budget. But at the same time, the movie industry set up a number for all brown. Oh, I missed it because it came down. I'm sorry, go back. I'm sorry. He was gone and then he came back. I'm sorry.
No, that's okay. And don't feel like you have to answer every question.
Okay.
Yeah.
So the ADA already has set up a number in the legal related to small business providing services, accessibility, accommodations. At the same time, with the movie theater, it should apply the same. It should be the same. And the screen should have the same number percentage, how often open captions are there. So before the panel, we discussed about Brown Burger, they both have promotes like numbers related to that. So I like their numbers, referring to that about the burgers, but now the same thing. I just want to make sure it's related, see if it's related.
Okay, Aleem and then Emily.
Oh, I can't. Oh, Eric and Breen and their research, they did say 12%. I would love to see more than 12%. And all accessibility to all theaters to make it fully inclusive. So some captioning, some movie theaters will be like the norm. So from the beginning, and then everybody will get used to it. Again, so 12% is a great start. That's wonderful. Okay. And if it gets more than that, even better.
Thank you. Emily?
Yeah, I just have a something short I want to say. And Eric and Brianna, they proposal. Yeah, I like their ideas. 12%.
Great. Last question for this panel. Are there days and times you wish there were open caption screenings that haven't been available to you?
Yes, 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 yes. Yes, all, yes.
Okay.
Well, yes.
Yeah, Andrea, did you want to specify?
I just wanted to add just a quick tag to that. I hope people keep in mind about so many problems with devices and so forth and screenings. Keep in mind that there's so few choices available as it is for open caption screenings, which are usually in the afternoon, usually on weekdays, not always, but often. And so a person who is specifically choosing an open caption screening to go and see, first, they have to figure out when and where it's happening. That can be really tough to do. Sometimes I wonder if theaters kind of bury that information so as not to scare people off. I don't know. But it's very difficult to figure out which screenings are actually open caption. So you plan your day around this. Maybe you get a babysitter, you plan your day around it. It's a big deal. You found your screening and you go to the movies, you go to your open caption screening, and then something goes wrong. You need to have more options and more times, preferably on evenings, and some premium times, like a Friday night, a Saturday night, something like that. That would be my suggestion.
Great. And then Dale, you'll be the final word.
First of all, letting people know clearly when they are, I think, is the most important. And second of all, even though I'm retired and I could go in the afternoon, evenings and weekends are the key times when anybody else I know goes. So I would say evenings and weekends, exactly what you put, I think, in the bill, is the most important.
Thanks, everybody. We'll now turn to our final panel of public witnesses. Ellen Valentino, Principal at Cornerstone Government Affairs. Doug Murdoch, Executive Director, Mid-Atlantic National Association of Theater Owners. Bobby Fiandra, District Manager of Regal Cinemas. Just give us a moment while we promote the panelists.
Rona,
Did it again. Rona, are you ready? Yes. Okay.
I'm ready.
Great. Ellen, when you're ready, you may begin.
I am. Thank you, Madam Chairman. I see the timer up there for us. My name is Ellen Valentino, and I'm here today representing the local movie theaters. As the committee and council deliberate over this legislation, it's going to be important to have an understanding of both the state of affairs of the movie theater industry and the current state of play of open captions in DC. You know, the state of affairs, DC currently has 7 first-run theaters, 1 second-run theater, 4 of which is closed since 2020. The hours of operation continue to change, with only 3 of the theaters open every day. An important note and differential, I think, you know, during the time of COVID, DC theaters were only one of only a couple of business sectors that were closed, mandated closed for over a year. DC theater box office revenues are projected to end 2023 at least 20% down. That is lagging behind the majority of the country. And even before COVID, but certainly as it stands today, families and individuals have movies, even first-run movies now, often at the tip of their finger, through the streaming services and the evolving platforms. But we do agree that there's nothing like seeing a movie on the big screen. As a business that are currently competing with home viewing, we have to work to ensure that every moviegoer has a great experience and can't wait to return for the next big picture. 5 years ago, when legislation was first introduced, we made a strong commitment to work as an industry to increase the number of open caption shows available across DC. This past weekend, that number of open caption shows hit an incredible number of 3,000 since January 1st of this year. Our testimony provides a list of those shows and locations, because I do think data is important when it comes to the deliberation here as the committee moves forward. You know, a snapshot example, during the first week release of the major blockbuster films, Barbie, Oppenheimer, and Mission Impossible, DC had a total of 85 open caption shows across theaters. So our commitment is strong. As mentioned, it has to be, because without every current moviegoer, we will not thrive. We're committed to work and to develop a policy, but there are problems with this legislation. It is too prescriptive and dated from theater operations today. One example is the marketing requirements. Local movie theaters do not market movies. Film studios do. Moviegoers are purchasing tickets online, picking seats before they arrive, and visiting theater sites and shows in the newspaper are long gone. Most importantly, there is room for an additional, there's no room for an additional cost mandate on the local theaters. And although there is one provision that calls on the Office of Disability Rights to do an awareness campaign, we welcome that, and we welcome to work with the advocates on that. It's just going to be important that the DC government bear all the costs associated with any outside marketing that may be required under this law. You have our commitment to work towards a policy and goal, but also understand the economic situation our industry is facing. Thank you.
Thank you very much for your testimony. Next will be Doug Murdoch.
Good afternoon, Chair Nadeau and members of the committee. I am Doug Murdoch, the Executive Director of Mid-Atlantic NATO, the regional affiliate of the National Association of Theater Owners, and we do represent the DC movie theaters, and I'm here to speak about the Open Movie Captioning Act of 2023. As Ellen said, our theaters want everyone to come to the movies, but certain parameters of this bill are very problematic to our operations. First, the bill outlines peak movie attendance hours that really vary and fluctuate depending on the movie, the film rating, the audience demographics, the time of year, the weather, and more. What may be considered peak for a college student may not be the same for a senior citizen or a parent and their children. As written, this bill has such tight restrictions on the timing of open caption shows that theaters would not be able to properly create schedules nor have the flexibility to react to market conditions. While we understand the intent is to ensure that open caption showtimes are not buried into a weekly schedule, requiring them to finish by 11:01 p.m. is just one of the problems. Let's take a recent example. The big blockbuster Oppenheimer, with its 3-hour running time, would have had to start by 7:15 in order for theaters to play their trailers and have the film finished by the required 11:01 p.m. cutoff time. The problem with that is that they would have to open up at 10 a.m. in order to just get 3 shows in for the day. These strict parameters would likely mean theaters would have to make the decision to shorten their operational day and potentially play just 2 shows a day on a film of its length. Beyond the running time, theater managers must stagger showtimes so that they can handle guests safely and efficiently. Not everything can start at the same time. Keep in mind, movie guests select showtimes based on when they start, not on when they end. And it's concerning to put such high penalties in place on something the theaters cannot control, such as the length of a movie. Further, the proposed penalties give no room for human or technical error. As outlined by Ellen, we are proud to have played over 3,000 open caption shows this year in the District of Columbia between those 7 full-time operated theaters. It's probably going to be closer to 3,800 to 4,000 by the end of the year. That said, we are very concerned about the 12% open captioning requirement outlined in the bill. If and when our theaters get back to operating full-time as they did pre-COVID, that could put the required number closer to 12,000 open caption shows per year. That's just in the district. That's far beyond any market demands. And let us keep in mind, most, if not all of the new films are playing at multiple DC theater locations simultaneously, giving guests many options to see any particular movie in open caption. That's a lot of show times for the same movie in a small jurisdiction. Ultimately, this legislation's one-size-fits-all approach to the timing and number of open caption shows simply would not reflect the marketplace nor the audience demand, and both would put added burden on theater operations. We are committed to playing movies in open caption. We just need some flexibility to do it in a way that serves both our guests and our theater operators. I appreciate you giving us the time to speak. Thank you, and we'll be happy to answer any questions.
Thank you. We'll now hear from Bobby Fiandra.
Thank you and good afternoon. My name is Bobby Fiandra and I'm a district manager for Regal Cinemas. I oversee operations in Maryland, Virginia, and the District of Columbia. This includes Regal Gallery Place here in DC. I'm here to express our concerns with the proposed bill as it stands. We acknowledge the intent of this bill, which is to make entertainment more accessible to all. This is a principle we embrace at Regal, and for that reason, we've shown open caption films at Gallery Place on a regular basis for many years. Just this year, we've played over 750 open caption shows at this location. That being said, we have significant concerns regarding the proposed requirements, especially given the delicate state of our industry. The COVID-19 pandemic was devastating to movie theaters, and we were among the last businesses permitted to reopen. During the 12-month closure, we maintained heavy fixed costs, and that dramatically compounded our losses. Our industry is still not recovered, and for perspective, our 2022 box office revenue at Gallery Place was down 56% compared to 2019. These circumstances ultimately led Regal to declare bankruptcy last year. We've only recently emerged from bankruptcy, and through that process, we were forced to close over 40 locations, including 3 of my former locations in Maryland. We've continued to face obstacles with cost increases, supply chain issues, and just recently setbacks related to the writers' strike. While we truly appreciate the intent to enhance accessibility, certain aspects of the bill, specifically mandating 12% of all shows to play with open captions, along with the stringent time and frequency requirements, pose very significant challenges to our operation. This isn't just about abiding by rules, it's about ensuring that our offerings remain varied and appealing to all moviegoers in the community. Regal Gallery Place recently collaborated with a community member to play all shows of Never Give Up in open caption. I believe this underscores how flexibility could enable us to respond to community needs. By removing this flexibility, the proposed bill would inadvertently eliminate our ability to respond in that way. Therefore, while we advocate for enhanced accessibility, we find ourselves unable to support the bill in its current form. We're not asking to take a step back, but rather inviting a step forward together. We'd like to urge everyone to work in tandem with us and our industry peers to revisit and reshape this bill. We believe collectively we could forge a path that champions accessibility without compromising the operational or financial stability of our theaters. Thank you all for your time and consideration.
Thank you all very much for your testimony. I have some questions. Given the large population of deaf and hard of hearing residents in DC and their impact on DC culture, wouldn't you agree that we should strive to be the national leader in theater accessibility? Go ahead, anyone can answer.
I've been involved with the DC theaters for years, and I think we are a leader. We have our district manager from Regal here, and I will tell you, they were among the first company in the nation to make a commitment. And they started playing open captions as much as 20 years ago, even during the 35mm environment. I think we are a leader. Certainly, there's always room to collaborate and work towards new goals, but I do think that they are a leader. All of the theaters in DC have changed their websites over the last few years so that they can prominently feature open caption. Some of the theaters have actually well exceeded what we asked them to do voluntarily. So I do think that we are a leader already. I do understand that folks would always like more, but I think we are a leader.
Can someone walk me through why the requirements in the bill would be an additional cost burden? Is that specifically the marketing?
The cost burden is not so much in getting another print. We have to get a second version of the film. It's not a button switch as referenced earlier in testimony. It's actually a separate copy of the film. That's not where our cost is. Our cost is in the lost shows that we may have. For instance, I mentioned Oppenheimer. If we have to play it at 7:15 in order to meet the requirements of the bill, we likely are not going to have more than 2 shows a day. Our cost is in a lost show. And it's also, we have seen through the years that that not all the shows are well attended. And so the cost factor is perhaps a little bit of the erosion of our audience. But is there actually a physical cost to go out and buy another copy of the movie? No.
And regarding the timing, the bill specifies an end by time. Is it easier to implement a start by time?
Absolutely. As I said, you make a reservation for a restaurant based on when you're going to get there, not on when you're going to leave. It's the same with the movies. I think it's very fair to say you don't want a midnight show. You don't want a 9 a.m. show. That's fair. And I think that's reasonable. And we'd be happy to work with you on what might fit the best. I will say that not all the theaters in DC operate on the same schedule. One of the newer locations tends to go later, whereas some of the older locations tend to go earlier. So it may be difficult to pinpoint a one size fit all, but I do think that there's something we can do there. But if we can get rid of the ending time, I think that's a great move forward for us.
What's the difference between the number of screenings this bill would require and the number of open caption screenings that theaters in DC already offer?
So the pilot program that we put in place in the summer of 2019, we basically said that every movie that opens, every brand new movie that has captioning available, we will play 2 shows, at least 2 shows in open caption during each of the first 2 weeks. After the first 2 weeks, we would drop it to 1 show unless there was a lot of audience requests for it. When we looked at the parameters of that pilot program, overall, we're getting about 4% of our shows. So it's about triple. And we also are concerned that the same parameters are there on week 1 versus week 5. As the films start to slow down, we don't show as many showings. So I do understand the 12%, but that alone is a very cumbersome mathematic thing that a lot of theater managers don't know till Monday morning whether a film will stay on Wednesday. So it becomes tough to predict, but hopefully that answered your question.
Sort of, I guess, just like how many more screenings would you be adding under this bill than you have right now is more the question.
So it depends on some of the operations. Some of the smaller theaters right now are only open 5 days a week. So certainly 12% is only going to yield maybe 2 or 3 shows, which is what we're kind of doing now.
Mm-hmm.
It's going to affect if we return to the business we had before. The theaters in the summertime used to open at 10:30 in the morning and go to 11 o'clock at night. They're not doing that now because they're trying to get a foothold back. So I would suspect that I think if the bill were to be placed into effect today, we are going to end up with at least 10,000 a year versus the 4,000 a year that we are already doing. So it's going to more than double, but we won't get to the 12,000 until we go back to a full-time operation.
Noting that you have disproportionately more screenings in the first 2 weeks of a film opening, what would you say would be the percentage within those 2 weeks?
I recall, I could get back to you, but I recall it was like 3.8% overall when we looked at it a couple of years ago, but I could get back to you on that answer.
Thanks. Do you have any data to show the difference in attendance between screenings with and without open captions?
We do. I'm still working on getting more. I will tell you that just yesterday, I heard from one of the theater circuits that gave me information that since the 1st of January, and they gave me all the number of open caption shows and the attendance, all the non-open caption shows and the attendance. And the difference was a staggering 60% between non-open to open. They were dropping by 60% during those screenings. That was just one company. I can't say that would be overall, but we will absolutely work towards that so that we can provide it to you.
Yeah, and please do control for, comparable show times. So we know, if those open caption movies were peak times or if they were, the off hours where you tend to have lower attendance. And then would those numbers be pre-sale or actual butts in seats, as they say?
The numbers that I see are the actual sales.
Okay. Are there differences in how screenings are being scheduled now compared to before the pandemic?
Absolutely.
All screenings.
Absolutely. All screenings, as I mentioned, a lot of the theaters have really curtailed their schedules. Some of them are open, full time, and then they close early on Sunday through Thursday night. But if we're referring just to open caption, I remember 5 years ago during the hearing, it was really brought to our attention that this was a need from the advocates. And at the time, there was only a handful happening. In fact, it was Gallery Place that was primarily being responsive upon request to do the shows. I think we've made great strides to be able to have about 75 shows across the district every week. Can there be more? I think we'll have to see how the future holds. for these theaters while we're still in this recovery mode.
How different are the captioned screening schedules across theaters in the district? Is each theater going their own way, or is there some consistency?
We actually designed the pilot program to kind of mirror the peak periods of the legislative proposals. Now, realistically, we tried to keep it before 11:01 p.m., but some of them do let out 11:30 just based on their length. But our goal has always been to try to mirror the legislation.
And the pilot was for all of the theaters that would qualify under the legislative proposal?
The original pilot program said 3 screens or more, so it didn't include the Avalon, which was only 2 screens, and it did not include the single screen that remains, the Miracle Theater. That is really a repertory sub-run theater. Almost, they only show a couple shows during the weekend, and most of them are older films.
Is there a way we can set expectations of moviegoers across the district while providing theaters with enough flexibility?
An expectation?
Yeah, how do we create standards for when and how open captioning happens, while also giving theaters enough flexibility to operate the way that you have traditionally?
I think we go back to the bill and we amend some of the language. Your offer to remove that 11:01 p.m. end time, that right there is a game changer because it opens up the evening a lot differently. I think the parameters still can be there. They just need to be not as strict. Right now, the bill says you can't start a movie before 11:59 a.m. on a Saturday or Sunday and it be included in this bill. Now, a lot of children and families go at 11 o'clock in the morning during those summer hours. So I think we just need to say a weekend starts at 5 o'clock on a Friday and ends on Sunday night. That right there would be giving some flexibility, but yet would still ensure that there are films available on the weekends and evenings as were requested by the advocates. And I will say that when we looked at these numbers, it was interesting. A good 50% of all the shows were happening on those weekends. And a good 25% were happening on the weeknights. And the remaining were just all over, mainly on the weekdays.
So the bill wouldn't prohibit you from starting a movie earlier in the morning. It just wouldn't count towards the 12%, right?
That is correct.
So you could certainly, if you found there was demand for family open caption times, do some morning ones in addition.
It's possible, yes. And I think that's part of the flexibility we're asking, is that if there is demand or a request, we'd like to be able to react to that. Bobby from Regal mentioned that back in August, they had gotten a request about a film that had someone in it that was deaf. So they chose to do the entire week in open captions. That wasn't a requirement, but it was like something that they felt was the right thing to do. And we want to do the right thing when we can.
But the bill also wouldn't prohibit you from doing that.
It would not in the current.
So let's talk about peak hours for a minute. I take your point that what peak hours may mean can differ by movie and time of year. Do you have any recommendations on how the legislation might account for that?
I'd like to get back to you on that. I still think that, as they said, weekends and weeknights are what would be when people like to go. There's still going to be peak. We all can say that most people go on the weekends. I don't. but in any event, I still think we can still keep those parameters there. We just don't want to have it such restrictive that you can't, you know, an R-rated movie is going to play better later in the evening than a PG movie that might play better in the morning. And I think that's just the theater managers are going to do what's best. We want the shows to do well. We want to attract the crowds.
How do you feel about the requirements that are now in effect in New York City? New York still requires showings at diverse times and during a defined set of peak hours, but caps the requirement of open caption showings at 4 per week.
The one thing that New York City did was they said that it would require a certain percentage, but it would be capped at 4. And so it ends up being 2 over the weekend, 1 on the weeknight, and 1 at any time. I think if we could reach to that in DC, that it's still a lot more than what we're doing, but it would be a better move than what the open-ended 12% would yield. That's really a scary number when you have something that's opening on many screens and could end up with so many shows that we know are just going to be poorly attended or not as well as perhaps the others.
There's been a lot of recent coverage of the change in consumer preferences for captions, particularly with younger generations. One survey showed that 60% of Gen Z uses subtitles or captions. Do you think the industry's been fully responsive to those changing preferences?
I do think there's a generational difference, and it's something that we want to continue to watch. When you think about the movie theaters, we've tried everything. We've tried Smellorama, 3D. If this is something that will work, we'll do it because it's great. But to mandate it doesn't give us the flexibility to respond throughout the years as we go forward.
Is there a way we can ensure a more open line of communication between audiences who may want more screenings and the theaters?
All of the theaters on their websites have a place where they can send in requests. They have, a button to push on their websites that says, if you'd like to request an open caption show, please let us know. And in fact, that's how Gallery Place learned about the request for that film in September. It was through their website. So I think the accessibility is there.
Okay. So let's dig into how requirements could be tracked and enforced based on how theaters are operating and how a theater manager works out a schedule of screenings. How much advanced planning is required to put together a schedule of screenings?
So the managers get their bookings finalized on Tuesday for the films that will start Friday. So Tuesday is their booking day. And that's when they lay out their schedule for the following at least 5 days. They can't always do the entire 7, depending on how the films may open on a Thursday night or Wednesday. But they basically work on it Tuesday. They post it as of Wednesday for that film to start Thursday night and beyond.
And what existing record keeping is there for theater screenings and whether they were captioned?
So one of the things that the theaters started doing a few years ago is now they have Oppenheimer and Oppenheimer OC. And so they can actually pull the information based on whether the show was played in open caption or Oppenheimer. I'm not sure that maybe, or not open. But I'm not sure all the circuits are doing it the same way. But absolutely, they keep attendance records by showtime, by movie.
How far back is that data kept?
I wouldn't be able to answer that question. Every company probably has a different reference.
Do you know if there's metadata or history attached to those files that could verify when they were last played?
I'm sure that there are. I am not knowledgeable about some of those specifics on how the theaters operate.
Ellen, go ahead, chime in.
Yeah, I just wanted to chime in because I think what you're getting at is trying to look at a trend or some data that when open captions were showed or not. And that's public in the newspaper, a lot of it. We have, the advocates have had a great Facebook posting that goes back. So, that's just one of the things as we look to it, rather than, asking competitors to give data to the committee, because we're not sure we're going to do. If you want to request a certain month, a certain time period, because I know one of the issues was what they're showing them in the morning or they're showing them at night. We can take that snapshot. I think we provided you the Barbie snapshot to show, the different times. So, but from an accountability perspective, I think that's, doable from just public searches as well. So I did just want to point that out from the metadata perspective. I don't understand that fully what you would be looking for, other than to say, I want to see when these shows were shown. I want to see where they were shown and, at what times, I would think.
Yeah, I mean, I think you're picking up on what I'm trying to determine here, which is
Right.
what's the best
Right.
way that we could we can do oversight of compliance. And
Right.
so, the final question really for you all is, what's the most streamlined way for a
Right.
theater to demonstrate compliance?
Well, let us do this. Let us get back to you. I think, it's always good to have it just publicly out there, because then it becomes crystal clear. You know how I feel? Then it becomes crystal clear about compliance. But I do think there's room here to work with your Office of Deaf and Disabilities. I think there's a collaborative opportunity here to market movies that are out there. But from a public space perspective, I think we hold ourselves accountable, because if we say one thing and do another, it's there printed on a website or in, black and white. Although I remember the days we used to look, where can you go and what time it is. So I think that's something that we can work collaboratively on with you and the city. But like I said, I think accountability is in the Google search and the theaters. But yes, we'd love to continue that conversation. That's one space we think makes absolute sense.
Okay. Thank you very much to this panel.
Thank you. Thank you.
Thank you.
Thank you.
Okay. Now we will turn to our government witnesses. All right. So that includes, we need a break. Oh, the captioner needs a break. Okay, we'll do a 5-minute break, and then we'll be with our public witnesses. Thank you. Government witnesses. We're back. Okay, so before you, so our two government witnesses are Matthew McCullough, Director of the Office of Disability Rights, and Andrea Gopelrud, General Counsel of the Office of Human Rights. Before you provide your testimony, I'm going to administer an oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you very much. Director McCullough, you may begin your testimony.
Good afternoon, Chairperson Nadeau and the members of the Committee on Public Works and Operations. My name is Matthew McCullough. I'm the Director of ODR. It gives me great pleasure to speak before this committee to provide testimony for Bill 25151, the Open Moving Captioning Requirement Act of 2023. ODR was created with the study of the Disability Rights Protection Act of 2006 by the DC Council. The agency focuses exclusively on the District of Columbia government's commitment to the Americans with Disabilities Act, also known as the 8A, and complies with all other federal and local disability related laws. This direction paved the way for the district to become a nationally recognized leader in ensuring that programs, services, benefits, activities, and facilities operated by the district are fully accessible to and usable by people with disabilities. While ODR celebrates the 60th anniversary of its establishment and the 33rd anniversary of the ADA this year, the agency continues to actively support and work to advance the protections available under the ADA and other laws impacting our citizens with disabilities as they relate to community living, employment, housing, transportation, emergency preparedness, and other vital government programs and services. The Open Moving Captioning Requirement Act of 2023 requires movie theaters to provide a specific number of open caption showings of each motion picture based on the number of screens in the theater. The bill also requires open movie caption screenings during both peak and non-peak movie attendance hours. This bill further recreates a notice and advertising requirement for movie theaters to provide notice to all customers of the availability of showing the motion pictures with open moving captioning. Failure to meet these requirements will be deemed an unlawful discriminatory practice under the Human Rights Act of 1977 to be enforced by the Office of Human Rights. Finally, the Open Moving Captioning Requirement Act of 2023 calls for the creation of an awareness campaign coordinated by the mayor and involving the mayor's office of the deafblind and hard of hearing, ODR, and other relevant agencies. DC is home to one of the largest deafblind and hard of hearing populations in the United States. Mayor Bowser is committed to providing an inclusive and accessible and equitable environment for all DC residents. This includes roughly more than 17,000 district residents representing the deaf and hard of hearing communities. The open moving captioning requirement of 2023 will help improve the moving going experience for resident and visitors who are deaf and hard of hearing, and help the district continue to be a deaf-friendly and inclusive city. Additionally, the open captioning requirement will not only aid those who are deaf or hard of hearing, but this service will also add other groups who may be relying on captioning, including patriots with autism and other developmental disabilities, learning disabilities, and those with limited English for purchasing. Requiring open movie captioning during peak hours will not only allow these communities to fully and equally benefit from the services that theaters provide, but these services will increase the number of patrons visiting these businesses while further strengthening the district economy. Audio fully supports the Open Movie Captioning Requirement Act of 2023 as it is another measure to ensure equal access to everything our great city has to offer to its residents and visitors. It benefits both people with displays and movie theater operators, and more people will get to enjoy the movie theater experience. It is in line with our DC values of equity and inclusiveness. Thank you very much for this opportunity to speak before this esteemed committee and the council about any questions you may have.
Thank you very much. And Madam General Counsel.
Thank you and good afternoon, Chairperson Nadeau, committee members and staff of the Committee on Public Works and Operations. I'm Andrea Goplerud. I'm the General Counsel of the DC Office of Human Rights, or OHR. Thank you for the opportunity to testify today on B 250151, or the Open Movie Captioning Requirement Act of 2023, which would require movie theaters to provide open caption movie screenings at various times. My testimony will focus on the operational impact of this bill, in particular establishing an appropriate procedure for adjudicating claims of alleged violations of the Act. As drafted, the proposed legislation would make a violation of the captioning requirements under the legislation an unlawful discriminatory practice pursuant to Section 231 of the DC Human Rights Act. Such a provision would require OHR to process caption violation allegations under the same mechanism it processes DHRA, the DC Human Rights Act, anti-discrimination claims. This means that OHR must first investigate the matter, determine whether there is probable cause, and if there's probable cause of a violation, the case is set for a public merits hearing before the Commission on Human Rights. OHR believes that this kind of protracted process is unnecessary and inefficient for a compliance provision such as the present bill, and therefore recommends that the Council consider amending this part of the law. Rather, OHR recommends that there is established a simplified process where OHR could simply determine whether there is a violation of the provision, rather than first determining whether there's probable cause to believe there is a violation. This will allow OHR to take on new cases in an efficient manner. Under our proposal, cases under B 25015 would be processed as follows. First, when OHR receives the complaint, like all complaints, OHR would first conduct an intake to review the complaint for jurisdiction and whether it states a claim. Then OHR would provide an early intervention, either through formal mediation or by investigator conference to attempt a resolution. If mediation fails, OHR would then request information from both parties. After this point is where OHA processing an investigation of anti-discrimination cases under the DCHRA and complaints under this legislation should vastly different. Instead of first determining whether there is probable cause to believe that a movie theater violated the requirements to provide captioning, OHR could proceed directly to making a final determination as to whether the alleged respondent failed to provide the captioning as required. OHR could make this determination based on the evidence obtained by the investigator, or depending on the issue, hold a fact-finding hearing where a hearing examiner could review the evidence and provide a proposed decision and order accompanied by findings of fact and conclusions of law to the director. Thereafter, the OHR director would review the record along with the proposed determination by the hearing examiner or the investigator and issue the final agency determination and order. If the council adopts the aforementioned procedure, OHR recommends making B 25015 a standalone bill rather than one that amends the DCHRA. It is not necessary to amend the DCHRA in order to create an enforcement mechanism for this legislation. In sum, OHR does not believe that compliance cases like those under the proposed legislation should have to go through the bifurcated process of a finding of probable cause and a certification to the Commission, as it will clog the system for adjudicating current discrimination caseload, and it will take longer than necessary to resolve alleged violations of B 250151. OHR believes that this type of streamlined process would be welcomed by the parties. If requested, OHR will be glad to submit a red line of the proposed changes. And of course, we welcome further working with the committee staff to address any questions or concerns. Thank you again for the opportunity to testify in this bill, and I welcome any questions.
Thank you so much. Let's start with questions for Director McCullough. Given the large population of deaf and hard of hearing residents in DC and their impact on DC culture, would you agree that we should strive to be the national leader in theater accessibility?
I think we should. We have a great opportunity to strive and move forward. I believe that even though our deaf advocates are 12%, I believe that there's an opportunity to broaden this conversation to go beyond the 12%. When it comes to the ADA, like the ADA is simply about doing the actual compliance. When you're talking about serving as a national leader for the United States, we're not just talking about actual compliance, we're actually trying to lead and find ways to have this critical conversation with those managers that may have questions about moving forward on how to actually conduct their day-to-day businesses within the movie theaters. Thank you.
Do you think the requirements in New York City go far enough?
I think it's a city by city situation that we can certainly adopt what New York does, but once again, if we want to have this critical conversations with the managers that are in operation of the cinema theaters in the District of Columbia, I think we can certainly adopt what New York is doing, but go beyond that. And I realize that the managers are concerned about some of the restrictions about the timing. And I think there's opportunities to have those ongoing policy conversations to broaden the timing. But based on what I heard from the leaders within the theater industry, money is not necessarily being lost. So in my mind, if there's opportunities to bring more deaf people, more hard of hearing and deaf-blind people into this conversation, and just realize we're also talking about senior citizens that are losing their hearing as well. So it's about time that we need to be inclusive and understand the audience that we're dealing with in terms of the moving going experience. Thank you.
Thank you. Are there other accessibility measures like sensory friendly or family screenings we should consider?
I think we do need to consider sensory type environments where people with autism and people that have trouble dealing with loud noises. I think there's ways to address those matters. Once again, it's an ongoing conversation with the parents, loved ones, and people who are experiencing these limitations to speak with the movie industry leadership and see what they need. I realize that the movie theaters allow people to send in the request for accommodation, but and I mean, if we're willing to move forward with the movie industry and bring in more customers, why do people with disabilities have to request what they would like? When it should be the offerings should be the same across the board. That in terms of open captioning, like I'm hard of hearing. I'm part of this community. I'm also a person with cerebral palsy, and so it's so tiring to consistently ask for accommodations for needs that are in need. And so how about we take a step back and understand the audience that we're working with and try to address those needs that aren't necessarily needed to request accommodation, but so we offer those services such as open captioning during the open week of an amazing movie like Oppenheimer for all the showings, like instead of just putting it at 12%, like the fact that Mr. Murdoch said, like it doesn't take too much to get moving in open captioning. It's just the overall operations of how the managers dictate how these showings are being shown in each theater. Well, it comes back down to management culture. And so it has nothing to do to the customers that they're trying to impact. And that's the difference that I heard in today's conversations, that it's not really impact. It's not the fact that the advocates are asking too much. It's coming back down to how the managers within those movie industry facilities are dictating how the showings are being done. So it's a management matter, not a consumer matter.
Good point. Do you think ODR should be the office to lead on the public education campaign, or is that more appropriate for the Office of Deaf, Blind, and Hard of Hearing? Or could be both.
Well, the thing about ODR is that we have always been supportive about this bill, but as you know, the scope of ODR, we solely focus on the ADA compliance of DC government facilities, programs and activities. If the bill allows ODR to work with the mayor's office for deaf, blind, and hard of hearing, and other agencies such as the Office of Human Rights will be there leading the way. It just simply has to state that ODR takes part in that awareness campaign, and that, but currently, due to the scope of what ODR does, it's more appropriate for the mayor's office for deaf, blind, and hard of hearing to do the awareness campaign in partnership with the Office of Human Rights.
What tools would your office have for an education campaign?
So we do sensitivity training on a constant basis. We in terms of, as you know, overseeing ODR for the past 6 years, we do reasonable accommodation processes, work with agencies. We can extend the same practices to the movie theater companies on how they should address reasonable accommodation. But when it comes to open captioning, you constantly heard from the deaf advocates and hearing advocates that they don't want to use those portable devices, because those portable devices, in my mind, are not equitable to the movie going experience. That you're setting aside a certain population, certain community, simply because you're giving them a device that in them makes them look different, and they don't want to be different. They want to be fully integrated in the moving going experience, and that's what those devices do. Granted, in all reality, based on the ADA, those devices, if they are very popular, do make the compliance. But in all reality, what the end goal of the ADA is community integration. So the Open Captioning Requirement Act will meet the community integration mandate of the ADA. Thank you.
Do you think there's a case to be made that theaters are not fully compliant with the ADA right now?
I'm not going to say that they're not compliant. There's always opportunities for them to do more. That if they're willing to offer more open captioning options at the movie theaters. I truly believe that they're worried about the financial backdrop that they experienced during COVID. I totally understand that. We've seen it across the district among all businesses, but I see the movie theater industry as a leader to rebuild our economy. And in order for them to bounce back, they need to get on board with this open captioning requirement act and offer more open captioning. The other thing that I mentioned is that I'm hard of hearing, and I also come from an education background that I fully understand that when it comes to our students with and without disabilities, there's a really comprehension deficiency that the district is facing right now. It's a good reinforcement for captioning to be offering much broader basis in the movie theaters. Our young adults, our young people are much more willing to embrace the open captioning, and the older generation is still a generation process, but I really believe that the more we offer in terms of open captioning, I would see an economic increase going on at the movie theaters because people are not staying at home streaming Hulu or what other
apps,
services there. They're out in the community. They're spending money in DC and not on these streaming services. That's what we want. And then I also believe that our young people with the open captioning, their reading comprehension will improve over time because they're constantly being exposed to this new set of leadership that DC is offering. Thank you.
Thank you. Does your office have any pre-existing relationships with movie theaters?
No, we do not, because once again, we don't deal with Title III entities.
Right. Thank you very much.
No problem.
Okay. And Ms. Koppelrud, thank you for your testimony. Would appreciate you submitting a red line of the bill with your recommendations when you have time.
Absolutely.
Awesome. I think you raised good points about the potential to streamline the administrative procedures to minimize the operational impact on OHR. Even under your proposed enforcement proceedings, do you have any concerns about OHR's ability to take this on?
I think I want to be clear about there's kind of two different things we're talking about. Is one would be the compliance statute is the which is specifically this bill is there movie theaters that are doing the 12% during the peak hours? Are they advertising it correctly? So that would be a compliance that we're talking about, a violation. But I want to make clear that if they're under our current law already, the Human Rights Act requires that all DC residents, people who work, who live, who visit DC are entitled to the full and equal enjoyment of services, including places of public accommodation, such as movie theaters. So if there are individuals who are not, even without open captioning, being able to have the full enjoyment of a movie theater because the portable devices are not working, that's already a claim that we would take and we could take because that's a violation of the HRA. So that's why a little bit I want to separate two of them already. The ones where if it's an individual who is not able to have the full and equal enjoyment for whatever reason of a movie theater because of their disability, they can come to us. That's already baked in. There's this additional legislation is not going to add to that our backlog or our workload. We already are able to receive those and may. In terms of the additional, what this would be under compliance, I'm not sure. This is definitely one that we're not sure how much of, there would be movie theaters or constituents who would come forward and say, well, it was 11%, it was 12. And so now we have to figure out and a fact finding. So, this is one of those compliance one that really is an up or down that seems, because we already have it under the HRA and protections for the individual, it seems a bit unusual for it to be under OHR. We're happy to do it if it's under a more compliance thing. But I just don't have kind of a way to gauge additionally how for the violations of these specific procedures, which is again, not that somebody doesn't have full and equal enjoyment of a movie theater. They are already protected. They should come to us and file a complaint. We have that baked in. This is just for whether 12% or whether it ended at 12:05 rather than, 11:05.
Yeah.
I just don't have a way to gauge how much additional compliance that would be.
Do you know if there have been any cases brought to OHR against theaters for closed caption devices?
I do not. I'm happy to get back with you and I will.
Okay. And oh, sure.
Well, I want to add to Andrea's points that not only can DC residents file criminal complaints through the Office of Human Rights under the Human Rights Act of 1977, they can also go to the United States Department of Justice and file under Title III of the ADA. And the larger movie theater companies such as Regal and AMC should be really concerned about their meeting actual compliance, because those two movie companies are in every 50 states and territories, and so they shouldn't necessarily be really concerned about this local bill. They should be taking a look and seeing they're really doing compliance under the ADA across the United States, including DC. So not only do our definite community residents have an avenue to file formally through the Office of Human Rights, they can federally to the United States Department of Justice as well through the Civil Rights Office. Thank you.
Thank you.
Director's exactly right. Thank you for including that as another additional recourse.
Thank you very much. Are there other provisions OHR enforces that are standalone and not under the DC Human Rights Act?
Part of that bill modified the rental housing agreement or housing act that provided that for prospective tenants, there is some do's and don'ts of screening prospective tenants, right? So there's a limitation on how much of application fee you could provide. You also have to provide written notice afterwards of if you rejected them for any reason and explain the reasons. That is not part of the DCHRA. But we have jurisdiction if there's a violation. That is one, though, that similar to this, that is a standalone bill, but what they did is similar to here, is they said that that should, though, go through our HRA investigation process that is with discrimination claims. That's one that, again, we don't think that that should go through the same process. I will give you one that does not go through the HRA process, which is not funded, but it's the Cannabis Non-Discrimination Act, or Cannabis Employment Act, apologies. And for that one, it's also a compliance statute. So that's ones that I would consider this. It's an up or down. Did you violate it or not? And in that one, unlike many of these compliance statutes where they have just said go through the HRA process, in the statute itself, it laid out a procedure that was much more truncated along the lines of what I mentioned in my testimony. And I cited to that bill in our written testimony as well. So it much more was this streamlined process that wasn't the bifurcated system through a probable cause finding and then a hearing before the Commission on Human Rights. There's several others, and I'm happy to chat on for all the others, but there are several standalone bills. I think about 6 or 7. I'm happy to give you an exact listing after this as well.
So it sounds like the Eviction Record Screening Act would be most comparable to what's being proposed here if it were a standalone, but that you think that cannabis might be the best practice.
I think cannabis also was actually a fully standalone bill.
Yeah.
So if anything, I think you don't even need, most recently was what Eviction Record did. But cannabis is fully its own statute, and within the statute itself, it has its own process for violations. So if anything, I think that that's probably the best example of what we would propose and recommend for this bill.
Based on the testimony of the industry, do you think there'd be enough information to actually do the appropriate fact finding?
Well, we're not looking at a trend. What we're really just having to do is say yes or no. So, we would have to get information from them about in terms of what the 12% is, right? And well, I think there's probably 2 possible violations. One, did you publish it? that's very easy, right? That, yes, I have enough data to say whether you published it correctly or not. But really it's the, the 12% and then in peak hours. I think, we have the ability during this streamlined process that I'm talking about to get information from either written submissions, or we could bring them in front of a hearing examiner. And I use that term, but it could be just that we are, bring them into a conference room where our investigators are, kind of talking to everybody, and we say, okay, give us this information. So I'm not exactly sure, but I'm not thinking it's a huge heavy lift either for them to determine, what the hours are, where the 12% is of a of a listing, movie listing.
Do you think, okay, so while the bill as introduced implicates the Human Rights Act, you could make the argument that this could also be considered a consumer protection issue.
Absolutely.
It should be fairly easy to confirm that the right number of screenings are being advertised, and if the film's not screened as advertised, that could qualify as false advertising. Do you think there may be another way of approaching the enforcement of open caption requirements? And I can offer that to both of you.
It's a little far outside of my field in terms of, consumer protection. I think that's right. It could be that. It could be a licensing, thing that you have to, I imagine, movie theaters every now and then have to go up for some type of licensing. And in order to do so, they have to show that within the past year, they've met this requirement. If not, then they don't get a renewal of their license. I'm happy to kind of spitball it more with my colleagues and give you some more suggestions. Again, but I'm also happy to defer to the director who may have much more better ideas than me.
I mean, I think, well, what I mentioned is that if we can tie this requirement to the license certification process when they have to go through the department buildings or what the other agency is in order to get the license back, I think that's a good reinforcement processing to include the certification of doing business again in DC. Thank you.
Thank you both. Anything either of you would like to add?
No, just appreciate it.
Thank you both. This concludes today's public hearing. If you've not yet submitted written testimony, please do so by submitting it on the page for this hearing on the Council's hearing management system, which can be found at lims.dccouncil.gov. The record for this hearing will close at 5 p.m. on Thursday, October 26th, 2023. The time is now 2:44 p.m. and this hearing is adjourned.